You got crickets? Is the House and the Senate chamber again?
All right, welcome to another day and another meeting for the Joint Corporations, Elections and Political Subdivisions Committee. We are in beautiful Douglas today. Hope everyone had a good ride up here. It's good to see everyone. Let's go ahead and take roll.
Morning, Mr. Chairman. This is roll call for Joint Corporations, Elections and Political Subdivisions Interim Committee, August 24th, 2023. Senator Barlow.
Present.
Senator Boner. Senator Landon. Senator Scott. Representative Chadwick.
Here.
Representative Haroldson.
Here.
Representative Harshman. Representative Knapp.
Here.
Representative Newsom. Representative Ottman. Representative Wiley.
Here.
Representative Yin.
Here.
Co-chairman Case.
Present.
Co-chairman Olson.
Here,
We have a full house and a quorum.
excellent. Mr. Co-Chairman, do you have any opening remarks or comments?
No, I don't. Go right ahead.
All right, let's jump into our first topic, which is elections. We do have a memorandum prepared by our LSO staff on poll watchers and elector intimidation. This was a request from at our previous meeting, if you remember, committee.
Thank you, Mr. Chairman. Yes, this is poll watchers and elector intimidation. This memo was, as you said, requested by the committee at the first interim meeting.
Maybe
And
just for the record, make sure.
oh,
you
sorry,
introduce
Mr.
yourself.
Chairman, thank you. This is Kelly Lower, LSO. Poll watchers serve a role across the country in protecting election transparency. Each state, including those surveyed, which is Wyoming and its surrounding states, has its own terminologies, duties, and qualifications for poll watchers. In general, poll watchers are appointed by a political party, candidate, or an issue committee to ensure their party candidate or committee receives a fair chance at winning an election. Some states specify who may or may not be a poll watcher. For example, a candidate whose name is on the ballot often cannot be a poll watcher. States usually require poll watchers to be registered voters in the state, and some require them to be registered in the county in which they are observing an election. The number of watchers may be limited at a polling location, and poll watchers are generally prohibited from disrupting the election process, intimidating or harassing voters, interfering with the counting of ballots, writing down any ballot numbers or other personally identifying information, taking photographs or videos of the election process. Several federal laws prohibit elector intimidation by any person, including poll watchers, as outlined at the bottom of page 1. Briefly, it's a crime to intimidate, threaten, or coerce any person for the purpose of interfering with their right to vote, whether the threat may be carried out or not. Each state surveyed, barring Nebraska, has a voter intimidation prohibition in their election code or criminal code. In each state surrounding Wyoming, voter intimidation by a poll watcher or anyone else is a misdemeanor offense. In Wyoming, it is a felony offense. Poll watcher qualifications and duties in Wyoming are as follows. Poll watchers must be registered voters in the county and certified by the county chairman prior to election day. And they may only serve at a location specified on their certificate. They may observe voter turnout and take written notes. They may not challenge voters, conduct electioneering activities, or disrupt the polling process. As with any other person, they may not engage in electoral intimidation as outlined on page 2, paragraph 2. In Colorado, variances from Wyoming's conditions for poll watchers include a training conducted by the Secretary of State's office. Candidates or family members of candidates may not be poll watchers. Colorado's voter intimidation provision is at the bottom of page 2. In Idaho, poll watchers' names must be submitted to the county clerk 12 days prior to the election, and poll watchers must always wear a name tag identifying their role. In Montana, poll watchers may not be a person whose name appears on the ballot. There must be at least one poll watcher per party permitted at a ballot deposit location for a mail ballot election. Montana's prohibition of electoral intimidation, as well as specific prohibitions for poll watchers regarding election interference, is on page 3. Nebraska also prohibits a candidate from being a poll watcher or a candidate's spouse. In South Dakota, a candidate may not be a poll watcher, and poll watchers may be directed to position themselves so they cannot see directly into the voting booth. In Utah, poll watchers may be any person registered or pre-registered to vote in Utah and may become a poll watcher at any time in an election by registering as a watcher with an administering election officer. And as I stated, each state has their own voter intimidation provisions, and they're under each state's headline. Mr. Chairman, if you have any questions or anyone from the committee.
Thank you, Ms. Lower. Committee. Any questions for Ms. Lower? No? Mr. Co-Chairman?
Thank you. And Kelly, I really appreciate the memo. I think it's good work. So Wyoming's the only state that has a felony charge for intimidation, but the part where the poll watchers are in the statute, no, sorry. It defines poll, it's 22-15-109 defines poll watchers. And it doesn't talk about intimidation or at all. It just says a poll watcher is authorized to observe voter turnout and registration and may make written memoranda, but shall not challenge voters, conduct electioneering activities, or disrupt the polling process. So I guess the notion that intimidation is, it doesn't say they can't intimidate a voter. Obviously, that's another separate statute about voter intimidation. So I really appreciate hearing all that. I hope maybe when the clerks come up, maybe on different bills, we could hear how they actually implement this and whether we did have a complaint. There was a lady that testified in the Lander meeting that she had been intimidated while trying to vote. And that's pretty serious. I don't know if it's ever happened before or if it's a matter of degree or how often poll watchers get admonished, but I think it's something we should take seriously. But it does sound like Wyoming has strong laws. Like many of our strong laws, I'm guessing the prosecutor never decides to go down that route. So, and one more thing, Kelly, do you know if there's a misdemeanor level of intimidation or is it just a felony?
Mr. Chairman, in Wyoming, I'm not aware of a misdemeanor level, but I could look into that.
Yeah. So sometimes when crimes are overly high, prosecutors will not even begin to go down that because it doesn't really fit what they think the crime is. So that might be something for the committee to think about if it's, but we'll wait and maybe the clerks could update us as we go along and maybe other folks.
Well, Ms. Lower, out of the other states that you surveyed, do they have misdemeanor intimidation provisions?
Yeah.
Yes.
Yes, Mr. Chairman, each other state has a misdemeanor intimidation provision, not a felony.
What is the primary distinction in those states between a misdemeanor and a felony?
Mr. Chairman, I could look into that further. Each provision I've found regarding electoral intimidation as a misdemeanor is a misdemeanor offense, varying degrees throughout the states. But I can look into that further for you if you would like.
Well, I think it's an interesting concept. I think if prosecutors, if you think prosecutors are chilled from actually taking any action because it's a felony as opposed to a misdemeanor, it seems like it would be a pretty easy thing to put in our statutes.
And Mr. Chairman, thanks for that. I don't know that we need to get rid of the felony, but it does seem to me that, some conduct that happens when people interact at a polling place, although it's improper, it wouldn't arise to the level of a felony. And if you're a prosecuting attorney, you're not going to go down that route. And it's like, we definitely see this, and I'm sure the attorneys on the committee see that there are many crimes that go unprosecuted. Because it's just doesn't exactly fit the circumstance. So maybe if we added, rather than replace the felony, but added, take a look at that a little bit more and derive some kind of a misdemeanor thing. And then have the felony for very serious intimidation. Maybe that'd be a way to go forward. I might point out that Senator Scott helped us a lot one time when we were looking at people who make mistakes when they're voting. And for sometimes, and we came up with a misdemeanor level of I guess voter fraud or whatever, but it was based on someone being really unintentional. And obviously, I don't think that applies here. This is going to be an intentional act, but it was a minor offense was allowed to be a misdemeanor, and we had other offenses in that remained a felony. That's just a thought.
Yeah, I mean, just looking at our definition of intimidation isn't a whole lot different than the Colorado and Idaho examples, but they classify them as misdemeanors. So I don't know. It'd be nice to know how often I guess we'll ask the clerks.
I think so.
All right, Ms. Lower, any other questions for Ms. Lower?
Thank you very much.
Thank you. Let's move to, we've got 7 bill drafts under elections. And I think the way we've set this up on the agenda, what we're going to do, committee, is we'll take each bill draft and take public comment on each bill draft in order to keep the conversation focused, rather than go through all the drafts and then take public comment. So we'll take them as we go. And our first draft, 24 LSO 0091, voter qualifications, durational residency requirement. Who's going to be introducing this one to us?
It's Lucas Plum.
Lucas. Floor is yours.
Good morning, Luke Plum, LSO. Here to discuss 24 LSO 0091. This is the durational residency requirement as a voter qualification. And so what this bill draft does is it amends several sections of statute. It's very similar language throughout, but pretty much anywhere that we are defining what a qualified elector is, we've incorporated a new provision. Already, a person in Wyoming has to be a citizen of the United States, a bona fide resident of Wyoming. They have to be registered to vote, and they have to be at least 18 years old on the day of the election. And so now this one, it just requires that the person has been a bona fide resident of Wyoming for not less than 30 days before the election at which he may offer to vote. And so there's one provision made in Title 18, but then the rest of the changes are made in Title 22 for the election code. And it does change the definition of qualified elector to incorporate that. And then it makes similar changes in terms of registration, the registration oath, and then just also definitions when otherwise the elections code is silent. And so that is, yeah. So there's Title 18, but then it's 22.3.102 is the qualifications for registration. 22.3.103 is for the oath. And then 22.29.104 is the following definition that just matches along with what is a qualified elector. This act is effective on July 1st, 2024. And I did incorporate a staff comment on page 6 just to briefly address what our neighboring states have done in terms of setting a durational residency requirement. 5 of the 6 currently do maintain some form of a residency requirement. Colorado has a 22 days. Theirs is set at 22 days immediately prior to the election. Idaho is 30. Montana is 30. Nebraska does not have an additional durational residency requirement, but you are required to be a resident of the state. South Dakota has 30 days. That was a new one just passed this year. And then Utah has a 30-day requirement as well. So that's generally the standard. Just to briefly address, I know there was a question about whether or not states were required to have a statutory provision or, to really truly address the federal requirement that any person who is otherwise qualified to vote be allowed to vote for president and vice president of the United States, even if they don't meet the durational residency requirement. And I will say that really, in a lot of looking, many states do not address the federal requirement. It's not really uniform. And some states have done it, some states have not. I haven't really found any case law that was directly on point, but I did provide Wisconsin as an example. They have a specific provision that specifies, because they have a 28-day durational residency requirement. And they do specify that even if a resident of the state, even if a person who has been a resident for less than 28 days is still entitled to vote for president and vice president, but no other offices. And the fact that the person was not registered to vote in the state from which they had moved does not prevent them from voting also. So just for the committee's consideration, whether that feels like a provision to be included, but that is, I think, overall the bill draft, and I'm happy to stand for any questions.
Lucas, you surveyed the states around us. Do we have a general idea of collectively how many states have a requirement on residency?
Mr. Chairman, I believe it's about half of the states. I know, I don't remember off the top of my head during the last meeting. I know in that memorandum I prepared, I think that answer is in there, so I could find that for you.
Okay, yeah, I feel like we did talk about that.
We did briefly address it, but and like I said, I'm almost positive it's 25. It might be now. I think, yeah, South Dakota just passed a bill to do it. So it's about half and half, roughly.
Okay. Representative Yin.
I get it. Lucas, thank you, Mr. Chairman. So Lucas, Luke, if I moved from Georgia to Wyoming in October of an election, a presidential election year, I'm no longer, and I consider myself a resident of Wyoming because I want to be able to register to vote here. I can't vote in Georgia anymore because I'm no longer a resident of Georgia. If I go to the clerk's office and they say I can't vote because of this law, do I have grounds to sue the state or to sue the clerk, or what would the situation be? What would the outcome be there?
Mr. Plum.
Mr. Chairman, Representative Yin, if this bill were to pass, and given that example, so under the, let me just make sure I'm saying the right one. It's 52 USC section 10502C. You would be allowed to vote for the president and vice president of the United States. That's required that a state would have to allow someone, even if there's a durational residency requirement. If you wanted to challenge the 30-day requirement, durational residency requirement, because you moved within 30 days before the election, I do think, primary challenge would likely be against the clerk, and and it would, but it is a statutory provision, and so it would just be a matter of whether or not you'd be allowed to register.
Do we need to clarify that in our statute, or we're okay because just leaving it alone because of the federal statute? Do we need to clarify that?
Mr. Chairman, not every state, actually quite a few states, at least from what I was finding, do not specifically have a provision that say, even despite our durational residency requirement, you are still allowed to vote for president and vice president. If you don't meet that, that's why I provided Wisconsin as an example. They're one of the few states. I don't recall off the top of my head how many states did have a provision similar to the one from Wisconsin, but it's a requirement the state would have to meet, but not all states really specifically spell that out.
Mr. Co-Chairman.
Thank you very, very much, Mr. Chairman. Lucas, a couple of questions, if you will. So the reason that we can't stop the president and vice president or require some residency is that no matter where you come from in the United States, you're entitled to vote for that. So if you come from Georgia or you come from Alaska, you're entitled to choose. For the federal offices, is it possible that a state would have, and I mean by congressional offices, Senate and the U.S. House, if a state were to have an extreme residency requirement, would that start to trip up into federal law with respect to voting for our federal election offices? For example, if you had make up a number, 5-year residency requirement or whatever the the extreme example would be, you'd run afoul of federal law at some point, I would assume.
Mr. Chairman, Mr. Co-Chairman, I have my memo, but I forgot to bring it up here, of course. There is the Supreme Court case that did basically say, Tennessee had a 1-year residency requirement, and the Supreme Court knocked that down and basically said, 30 days kind of makes sense so that you can get ready for the election, make sure that you're good to go there. But based on that case law, I think it would be that's where you would really run into the issues. And that's why I think it's most common to see a 30-day residency requirement, because that was kind of the standard set by the Supreme Court.
And fair enough. One more, Mr. Chairman.
Mhm.
So currently, when you've registered to vote, you say that you are a bona fide resident of Wyoming. That's the extent of your oath. So what is going to be the difference between a bona fide resident and a 30-day bona fide resident? So is bona fide, you can become a bona fide resident upon driving across state line or upon having a domiciled? What does the bona fide mean? And I'm sorry, you probably covered this in Lander.
Mr. Plum.
Mr. Chairman, Mr. Co-Chairman, there's discussion of residency and statute. I do not know off the top of my head. I could provide that information. I don't know if I went into depth in it in the memo I provided at the last meeting. But there is some discussion that, you have to be basically making Wyoming, you have to have the intention to make Wyoming your residence. And similarly to like how right now, you just swear to that you would be a bona fide resident. That would be a similar, at least how the bill is currently drafted. You would just swear to the fact that you have been a bona fide resident of the state for 30 days.
Thank you, Mr. Chairman. Senator Scott and others down there.
Senator Scott.
Yeah, Mr. Chairman, my question is the interplay between our laws and those of the other states. What I've observed talking to people that are just moving in election day is they've often voted absentee in the state they were leaving before they left. And do we know what the laws are in other states, such if somebody was moving in the last 30 days, would they have been eligible to have voted absentee where they came from? Because that's, I think, the practical solution that people are using.
Mr. Plum.
Mr. Chairman, Senator Scott, I don't know if I have a great answer for you. I think certainly even in our statute, I don't have it specifically, but if you're in Wyoming, but you haven't made it your official residence, a lot of places will say, okay, if you haven't officially become a resident of another state, but you're kind of moving, there is some ability to be able to vote in that other state, and it can be absentee, but I would have to look into that question a little more closely to be able to give a better answer.
Senator Scott.
Mr. Chairman, in the old days, and I don't think it's still part of our statute, but in the old days when there were the lengthy residential requirements, we would explicitly permit somebody who was moving elsewhere and wouldn't qualify to vote here. And I think we got rid of that a number of years ago because nobody had the lengthy requirements anymore.
Representative Knapp.
Mr. Chairman, I just had a detailed question, Lucas, and that is throughout.
No detailed questions.
Oh,
Okay, go ahead.
all right. Throughout the bill, we refer to the individual as a person. On page 4 at the top, we use the definition of he has been a bona fide resident. I just wondered if that was meant to be there or that would continue to be consistent with the
Representative Ottman.
Thank you, Mr. Chairman. Just to go along with this, it seems that there was a question and I wanted to know too what bona fide meant. So I looked up a couple different places and in some places it is defined as sincerity. But going way back to the definition, it means the authentic, genuine, and legal. So in order to alleviate any question on someone's sincerity, do we just need to change bona fide to legal, or is it understood to be legal?
Mr. Plum.
Mr. Chairman, Representative Ottman, I think that's really kind of a question. I think bona fide does provide that definition. It's not specifically defined in the election code. And so really, I think it would be up to the committee which one you think would be more appropriate to use.
Representative Ottman.
Thank you, Mr. Chairman. Yes, so in the back in the definition, when we were looking at vice president and president along with the federal code, does this mean that, and just for a point of clarification for myself, if a state must allow for the vice president and presidential election, does that mean, again, just for clarification, that they have to allow for all of the other, or would there just be a ballot for that person with the vice president and president of the United States?
Can I take a time out and just for housekeeping, Mr. Chairman?
Sure.
I understand our video feed is off, so you probably know that. But if you didn't, you do it. Thank you very much. Sorry, Mr. Chairman.
Yeah, it looks like they're working on it.
Yes.
We're back up. Okay. Mr. Plum.
Mr. Chairman, Representative Ottman, really by the language of that specific federal statute is that any person who is otherwise qualified, in an election for the president and vice president cannot be denied the right to vote based on their durational residency requirement of the state in which they reside. I think that likely is read. I think Wisconsin is a good example where they specifically say that a person who is otherwise entitled to vote is entitled to vote for the president and vice president, but for no other offices. I think that's the way the federal statute could be read, but I think that's like the bare minimum. And I think it would be kind of determinative. Yeah, whether I think that's the floor, right? Like, do you have to allow someone to vote for president and vice president? I don't think it necessarily requires that you allow a person to vote for everyone, or that they have to be able to vote for every, federal office. I think it's specifically how that section reads is specifically for president and vice president of the United States.
Senator Landon.
So thank you, Mr. Chairman. I'm just trying to play forward as representative at the other end of the room has done into the election itself. And how does that play out from a legal standpoint? And what's it going to do to our volunteer group that runs our elections in Wyoming? I'm just trying to, if we put this 30-day in, but not for the president, vice president, is that going to require a separate ballot that they would hand? Because you don't want any of your elections officials looking at a ballot just to make sure that person only voted for those two, correct? I'm just trying to play this out. I don't have any problem with the 30-day, but whether we require that for, anyway, I'm looking at one of our legal advisors here who happens to be the chairman. Let's just say that somebody breaks that rule. What are we going to do about it?
Mr. Plum, do you have any idea what the balloting would look like in those states that have residency requirements?
Mr. Chairman, and Senator Landon, I don't know. I did not look to see specifically how Wisconsin handled, if they had a separate ballot that only included for president and vice president on it, but that might be the case. I am not sure.
Mr. Chairman.
Mr. Co-Chairman.
Thank you, Mr. Chairman. So just to kind of follow up on that horse, we have problems with voter anonymity now. So if you had a separate ballot for just president and vice president that you gave out to people that were only qualified to do that, but you did it, you'd still have to do it by precinct or by count. I don't know how you do it. But if you had one person per precinct, then now you know how that person voted. And, you know, that violates our Constitution. So there's something to think about there. And Mr. Chairman, I have kind of another question. There's a federal registry, as I understand it, that some states participate in, some don't, and some are withdrawn from, of people so that the states can't double up on people voting. And it makes sure that states can check to see if someone's registered in another state. And I believe Wyoming belongs to that, but I'm not sure. And I guess if other states don't participate, it's not all encompassing. But if that were all encompassing, it would fix this whole problem of someone voting in another state. And, you know, voting in two states. So I'd ask about that.
It's probably a question for our clerks.
Probably, I don't know. Mr. Plum's really smart.
Mr. Plum, do you know?
Mr. Chairman, Mr. Co-Chairman, I don't know if I have a great answer to that. It might be better for the clerks.
Tee that one up.
Mr. Chairman, if I may.
Yeah.
There is a definition of residence in statute.
Okay,
And I can copy that and send it to the committee on the whole, because it is fairly extensive. It provides quite a bit of what is a residence, and it provides rules that govern it. I'm sorry, I skipped to the wrong one.
I think one thing I might like to see if this bill moves forward is actually just putting that residency requirement or residency definition in the bill. So it's just right there. Existing, it'd all be existing language, but it might be helpful. Because I can see that question coming up 100 times.
Yes, but it is, Wyoming statute 22-1-102 A30, if anybody's interested.
Okay. Sounds good. Senator Scott.
Mr. Chairman, the general question I have, for anybody else specify.
Is your mic on, Senator Scott? Can you light that up for us? Thank you.
The general question I'm going to have is, why bother? What is there that is causing the need for this bill? That's probably not a fair question for the LSO. So my question to the LSO is, what caused you to draft this bill draft? Who asked for it?
We asked for it, Senator Scott.
We did, the committee did?
Yeah, that's right.
Okay.
Careful what you ask for. Yep. Co-chairman.
Oh, I'm sorry. I was just saying, maybe it's time to hear what the public thinks about this.
Yeah, and I think we can move into Secretary of State and our clerks, which I think will be helpful as well.
That's-
Mr. Secretary. At least two of the questions that we've had so far, I know you may be able to answer, Mr. Secretary, the balloting question regarding presidential elections, but also what problem does this solve? Why do we have it in front of us? Because I think both.
I've taken a lot of notes, Mr. Chairman, from the back and forth, and
Oh, good.
is it okay if I go?
Sure.
All right. Well, I'm Chuck Ray. I'm the Wyoming Secretary of State, and of course, joined by Joe Rubino, our Policy Director and Counsel to the right. And first want to say I really appreciate the committee for agreeing to do a bill draft on a suggestion we had on our first meeting. We had presented that we thought this was something that you should take up in the interim. I'm in complete and total support of imposing a durational residency requirement. At present, Wyoming remains one of a few states without some sort of durational residency requirement, and effectuating appropriate requirements like a residency requirement help to ensure integrity in our elections by making sure Wyomingites and only Wyomingites are voting in our elections. Now, wanted to note a few things in terms of the bill. I believe it's essential, holistically want to start there, to ensure that Wyoming has safeguards in place to strengthen Wyoming's residency requirement and ensure that there is a durational aspect to ensure Wyoming's elections are decided by Wyomingites. And I think that in terms of what we're trying to get at here, I think it's very important, and it gets to the clerk's memo and also I think their discussion and some of the questioning here. I think it's important that we focus on the durational aspect in this rather than the definition of residency. And I agree, there are a lot of things with bona fide resident that maybe we can look at here, but I think that is a separate question. I think the question here is whether with the existing definition, whether we want to have a durational aspect, which again, was an aspect of Wyoming's constitution. Our constitution had a year-long durational aspect that was thrown out in a series of cases. One was federal, 1972, and then the Wyoming equivalent was in 1973. And since then, the legislature has declined to act, meaning that we have no residency requirement in statute, and I believe it's a huge hole in our statute. But again, this was an aspect of our constitutional structure, and the opinion in 1973 and the one in 1972, the subsequent case law and actions by states surrounding us and across our nation have been in support of durational residency requirements, albeit at a lower number. If you look at state constitutions, this was an aspect of over 30 state constitutions had a year-long residency requirement that was supplemented by statutes in the founding of our nation. And then there were actually 2 states that had a 2-year residency requirement. So the point of the case law from the 70s, I think, was that those more stringent ones were thrown out, but they did through the subsequent action and also in those decisions contemplate that some form of a residency requirement would be allowed, and that's played out across numerous states. As to the LSO, I want to switch gears here, talk a little bit about the interaction with federal law and engage in a little bit of a colloquy on this question of breaking out ballots and the federal law, the amendments to the Voting Rights Act and what that requires and what it doesn't. So as to the LSO staff comments on this and subsequent questions, I want to be clear that both the amendments to the Voting Rights Act and the Supreme Court cases that followed interpreting the amendments to the Voting Rights Act have resulted in varying degrees of application and implementation by states. On this note, I want to point out a couple of provisions for the committee to consider. While LSO staff has pointed out 52 USC 10502C and its effect on elections for president and vice president, the way the bill is currently drafted, which mirrors in large part Idaho's durational residency requirement, may alleviate some concerns that additional language is needed to require separate administration of elections for president and vice president. Specifically, 52 USC 10502E provides, and I am going to quote this, change of residence, voting in person or by absentee ballot in state of prior residence. If any citizen of the United States who is otherwise qualified to vote in any state or political subdivision in any election for president and vice president has begun residence in such state or political subdivision after the 30th day next preceding such election, and for that reason does not satisfy the registration requirements of such state or political subdivision, he shall be allowed to vote for the choice of electors for president and vice president or for president and vice president in such election, 1, in person in the state or political subdivision in which he resided immediately prior to his removal, if he had satisfied as of the date of his change of residence the requirements to vote in that state or political subdivision, or 2, by absentee ballot in the state or political subdivision in which he resided immediately prior to his removal, if he satisfies, but for his non-resident status and the reason for his absence, the requirements for absentee voting in that state or political subdivision. Now, that's a long quote, but in Oregon v. Mitchell, which has been considered a patchwork of opinions that generally upheld the amendments to the Voting Rights Act, Justice Stewart's wrote in a concurrence, spoke directly to the impact of this provision and squares it with 52 USC 10502C, which is what LSO pointed out as a potential conflict, stating in part, quote, Section 202 added by the Voting Rights Act amendments of 1970 is a comprehensive provision aimed at ensuring that a citizen will not be deprived of the opportunity to vote for the offices of president and vice president because of a change of residence. Those who take up a new residence more than 30 days before a presidential election are guaranteed the right to register and vote in the state to which they have moved. notwithstanding any durational residency requirement imposed by state law, provided, of course, that they are otherwise qualified to vote. Then he continues, those who take up a new residence less than 30 days before a presidential election are guaranteed the right to vote, either in person or by absentee ballot, in the state from which they have moved, provided that they have satisfied as of the date of their change of residence the requirements to vote in that state, unquote. Given the current, now continuing with our comments, given the current LSO drafts provision of a 30-day durational residency requirement, Justice Stewart's interpretation of the amendments and explanation is helpful. As it applies to Wyoming, this could mean that a person who moves to Wyoming more than 30 days before a presidential election is guaranteed the right to vote because they will be allowed to vote under Wyoming's durational residency requirement. And those who move less than 30 days before a presidential election under Section 10502E will still be allowed to vote for president and vice president in their old state, meaning we do not need a breakout. Because the draft mirrors Idaho's language, our office reached out to our counterparts in Idaho, as they are similarly situated in that they are exempt from the National Voter Registration Act and also have a 30-day durational residency requirement. Specifically, we asked if they conduct different elections based on president and vice president, whereby new registrants who do not meet the 30-day residency requirement will not be prevented from voting for president and vice. In response, he noted that Idaho does not have different registration standards for state elections and those for president and vice president. Rather, Idaho's 30-day residency requirement to vote applies regardless of election type. He also gave an example. If someone had barely moved to Idaho, let's just say 15 days before an election, and they wanted to vote here, they would be told by Idaho election officials that they could vote in their previous jurisdiction since they had not met the 30-day residency requirement. Given Idaho's similarity to Wyoming and the complexity of administering two different elections for president, vice president, state and local elections, I think it would be prudent to examine this carefully, and I do not think we would need a breakout. I also now want to switch gears and talk a little bit about the comments by the county clerks. I am in complete and total agreement with the county clerks that we need to look at the definition of a bona fide resident in the future. However, I believe this lack of clarity exists regardless of any changes to a durational component of residency. And I think we have more than enough on our plate here on the durational aspect. For example, right now, Wyoming statute still requires that to be a qualified elector, a person must be first and foremost a bona fide resident of Wyoming, and this does not change with any durational aspect. And we are working on solutions to this with the clerks. In conclusion, I stand in total support of Wyoming adopting a durational residency requirement. I do not believe that adding additional language concerning elections for president and vice president is necessary, and I do not believe it would be advisable in an election year to do so.
All right, Senator Landon, did that answer your question earlier about the two ballots? Did
Mr. Chairman, yeah, I think it is an answer. I still am trying to take this to the election day and to the day that we try to pull off an election. And I think there's some really important points made by our clerks with regard to how are we going to pull this off? I mean, what sorts of documentation are we going to require, and how much work is that going to be for the volunteers who run our elections? I think it's one thing to pass a billboard law, but there's some practical ramifications is where I'm going with it. So
Mr. Secretary, practically walk us through what you think it looks like when a citizen shows up to vote, and they're walk us through what it looks like when they're under 30 days, and then walk us through what it looks like when they're over 30 days.
Well, Mr. Chairman, and I think this is an important thing to note. I wanted to say this during my normal comments. I'm glad it came up in the question and answer. The bottom line here is that this is an attestation. It's an oath. We have our existing requirements for registration. We have our existing requirements on voter ID. Those remain in place regardless. And right now, it is an oath that you take that you are a bona fide resident. And this updates the oath to say that you've been a bona fide resident for 30 days. So it would just be an attestation, which is current practice, in addition to our registration and voter ID requirements, which are separate. So really, there's no other change other than the oath has changed and you are perjuring yourself if you're lying. And that is how we've handled bona fide resident. But I believe that we're going to get a handle on some of these cases where we do not have Wyomingites really voting in Wyoming elections by having that 30-day requirement. You put an oath in front of somebody in concert with our registration and voter ID requirements, and that I think is going to be effective. But it's totally in line with what we do currently. Totally.
Representative Yin.
Mr. Chairman, thank you. Secretary Gray, in your statement, you said that the reason that you brought the suggestion for us was to increase election integrity. And then just now you mentioned that there were cases where people who were not Wyomingites are voting in Wyoming elections. Can you elucidate on any of those cases that you've seen where people are voting in Wyoming elections when they shouldn't be?
Well, Mr. Chairman, I was engaging in a discussion of what could happen. Again, voter fraud is a very difficult thing to pinpoint, and we're working on that a great deal. But I go back to conversations I've had with the clerks to when I first drafted a voter ID, and then when we had a Zoom back in 2020, and this identified as a potential issue. I asked the clerks on that Zoom, I've asked them numerous times on meetings since then, if somebody showed up at a hotel and was here for 5 days, and if they said they were looking for a job, satisfied the registration requirements, which arguably they probably could, satisfied the voter ID requirements, which I would say they definitely could, would it be a prosecutable offense for someone who was in a hotel? And I have been told numerous times to that, no. That I think is a problematic hypothetical. Do I have a specific example with that? No, because we don't ask and when they go in, because there's no statute to that effect. And so again, it goes back to voter ID. I mean, whenever we try to bring these election integrity measures, we almost engage in this circular sort of conversation where it's, do we have specific examples? The answer is no, because there's no way to identify them because of the system currently in place.
Mr. Chairman, follow up.
Representative Yin, follow up.
Mr. Chairman, thank you, Secretary Gray. So you're saying this is a hypothetical. Haven't been sure if it happens, so we're frankly tilting at windmills, in my opinion. But let's say we do enact this law. How are we going to know that that's happening, that people aren't just because like you said, it's an attestation at the very end. Maybe people are perjuring themselves to do it. How are we going to find those cases? Even if you say we need this law to be able to find those cases, how do we know that that's going to happen now?
Mr. Secretary.
Well, Mr. Chairman, again, I was engaging in a potential fact pattern that could play out. So if we received a complaint, and then we'd have a statute to prosecute. Somebody was in a hotel, had been able to register, which I think in some instances they would be able to. If they were able to satisfy voter ID, which I'm confident they would be able to, and we received a complaint, then we would refer that. And I believe there would be a clear prosecutable offense. Right now, there is none, and that's problematic.
Mr. Chairman, but there's never been any complaint of that effect before?
Mr. Chairman, we don't have records back to, ad nauseum, but I've heard anecdotally all sorts of things. And that was before I entered office. We haven't had an election during my time in office. I was sworn in January 2nd. So we haven't had an election during that time. But obviously, any of that anecdotal information that I've been privy to for years, now I'd have the authority to investigate through our formal complaint process, as well as the clerks, communication with the clerks.
Senator Boner.
Okay, thank you, Mr. Chairman. Thank you, Secretary. Very good to see you. Welcome back to Douglas. So just want to make sure I have some clarity on your position versus the clerks. It seems to me the clerks want to have some method of, verification that somebody's been in Wyoming for 30 days, maybe they'll have a chance to come up and explain their own position. And your position is simply if we make that the law, then we're relying on basically there being a deterrent factor, and that, even though we're not actively verifying the fact that they've been there for 30 days is still the law, and if they violate, it's a prosecutable offense. And as such, it's a relatively simple fix to make before the next election. We can worry about adding the verification mechanism later, if at all. And so is that a accurate understanding of, maybe it seems like there's some daylight between your office and the clerks. Is that an accurate statement?
Secretary Gray.
Mr. Chairman, I really appreciate that question. I don't think there's daylight. I think there are different points of emphasis. The clerks are very concerned, and I am, about this upfront thing, and they're trying to bring that to the attention, the proof. But they flat out say in the memo that they don't believe the fix is statutory there. That's something that we need to engage in through our practices. They want to bring it to your attention. I do as well. I do, having been a former legislator, I want us to focus on this. I think it's a big bite. I think it's important we engage on some of the ancillary issues that exist regardless, but I think there are different points of emphasis. But I think the memo, the way I read it, and also in our meeting that we had a few weeks ago, I think we're on the same page on how we move forward with the bona fide question. And I think there is some work we need to do on the definition and statute as well, but that I think is a separate question. And I think they acknowledge that at multiple points in their memo. So it's a slightly different emphasis, but I think we're on the same page. Actually, they were clear on the policy question here that they're not, per their policy, going to weigh in on that, but they make clear that it's administratable. And I think from their 13-page memo and my conversations with them, I just have so much respect with how interested they are in this topic. They do not want non-Wyomingites to vote in Wyoming elections, just as I don't. And so, whereas we're engaging in more of a policy stance per our practice, and the fact that, our practice in the Secretary of State's office. So I just think it's different points of emphasis, but I think we're on the same page on the end goal.
Senator Scott.
Mr. Chairman, I want to ask a question about a different segment of the population. I think we might get in trouble with this. And that is the part of the population that is just plain so mobile, it's hard to pin down where their residency is. I'm seeing it in my district with people who are working the oil patch, and there'll be a few months in North Dakota and a few months in Texas, sometime in Wyoming, and it's hard to say where they really are resident. With the current law, they're resident wherever they happen to be on election day, and they can come and vote. So that's one population that is, Mr. Chairman, quite mobile. And then I'm starting to hear people my age that sell their house, buy a mobile home, and again, just don't have a stable residence. And if they have some base here, they'll claim that and will be a resident here on election day. But are we going to create problems for that segment of the population with this?
Secretary Gray.
Thank you, Mr. Chairman. Another great question. We've engaged in a lot of discussion with that within our office, and I'm going to turn this over to our counsel after I give my initial answer, because we've had a lot of colloquies on this the last few months, and also with the clerks. And I think we're fine here because this is a 30-day residency requirement within the state. So if the situation you played out, mobile home, we were thinking a lot on the indigent question. Say someone is living, by the, pick X hotel, outside the X hotel one day, and then they move to another location within Casper, maybe by the river, day two, they are still a resident of the state. So as long as they aggregate that across 30 days, they've qualified for the durational aspects. There is a lot of questions on, I think, regarding where that vote is allocated, and that's something we've talked with the clerks about, but that is again a separate question, where that registration happens. The practice has been to make it at the courthouse, which does have some implications. But that has been a practice that has been longstanding for the county clerks, and I think is definitely a separate question. But as long as they aggregate that 30 days within the state, then they've qualified. That's the way it's worded. So somebody moving from place to place who's indigent or in a mobile home, moving their mobile home, they're aggregating that as long as they're within the state. And that's in line with our intent to make sure Wyomingites are voting in Wyoming elections.
And Mr. Secretary, I think it really boils back down to that attestation or that affidavit, because the residency by definition doesn't necessarily mean where you're physically located. It means where you have an intent to return to. So even if you were in the oil field and you were going from state to state, if you intended to return to Wyoming and it was your residence, you could swear to an affidavit in all honesty that it was your residency because you intended to return. That's part of the definition.
Yeah, Mr. Chairman, I think that's a great point. And that's all I was going to add was, because it's an attestation now and you are signing under oath.
Do you
when
want to
you
give us
register
your info for the record?
What's
Your
that?
name?
Oh, Joe Rubino.
Yep.
Yeah, thank you. I'm the policy director and the counsel for the Secretary of State. I think that addresses that question, and that's when you would get into all sorts of scenarios. You pointed out mobile workers. You also pointed out some snowbirds or things like that. There's a reason that I think, though, that a vast majority of states have adopted a durational residency requirement, is that it's a policy question that their legislatures have undertaken to determine they want their residents to have an interest in that state or intend to return to it and be there for the 30 days prior to the election. While I have that, I also wanted to address a question that came up during Mr. Plum's comments, and it was from Senator Scott. We still do, Wyoming does, and the vast majority of other states still have statutes that comport with 52 USC 10502E. Ours is found in 22.1 Wyoming statute 22.1.102 subsection A, Romanet 30. And again, just to remind the committee, this is subsection E provides that you'd still be able to vote at the state that you've removed from if you don't qualify for the residency requirement of the new state. Romanet 30 provides if a person removes to another state with the intent of making it his residence, he loses his residence in Wyoming, except that in a general election year, if his registration is valid in Wyoming when he leaves this state and he is unable to qualify under the laws of his new state of residence to vote at the primary or general election, he shall be deemed to have retained residence in Wyoming for purposes of voting by absentee ballot in the primary or general elections.
Senator Scott.
Yeah, it's 22, Wyoming statute 22.1.102 subsection A, Romanet 30, and then big letter E.
And committee, with the exception of Senator Scott, who doesn't use email, the LSO staff has sent this definition to us in our email, so you can pull it up and take a look at it during the discussion. Senator Landon.
Mr. Chairman, thank you. Mr. Rubino, thank you very much for being here. And I think I speak for a lot of us who are very interested in making sure that it's Wyoming people who are voting in our elections. My question to you is why the 30 days versus just stating in our statutes that we expect you to be a resident if you're going to vote in our election? Talk me through the difference.
Right. Mr. Chairman, thank you, Senator Landon. I think the secretary's already addressed this point. And that's a policy question that obviously other states have already made, but it's the scenario that the secretary had pointed out during a Representative Yin's line of questioning, which was that this is getting at preventing a person from moving here with solely the intent of staying in a hotel for a couple of days, if in that situation, they'd be allowed to vote. Would there'd be no real argument that they wouldn't. And so it creates an incentive for people to come to a state simply to be there. There'd be no argument under our present statute because the definition of residence is intent to return, that staying in a hotel for just a handful of days wouldn't be sufficient to vote in that election.
So a follow
Senator
up, Mr.
Landon.
Chairman. So it would be perjury either way, correct? I mean, really, if someone walks in, even. I guess I'll stop there. Wouldn't it be perjury either way? You have to tell the clerk that you are who you are, and I'm a resident here.
Mr. Chairman, Senator Landon, no, it would not under current statute, because our statute and the definition around residence is intent to return. No, I think it would be very hard to prosecute that, and it would not be perjury if you truly intended to return to that hotel for one day.
Okay, thank you.
Mr. Co-Chairman.
Mr. Chairman, I'm having difficulty fitting that into the oath that you sign that says you're bona fide resident.
Mr. Rubino or Mr. Secretary.
Mr.
That
Chair,
seems to me, just to clarify, a higher standard than being in a hotel room for one day with some intention of coming back to that hotel room or that hotel sometime. Bona fide, the oath now says you're a bona fide resident. So how does that play together?
Mr. Secretary.
well, Mr. Chairman, one of the things I've always engaged in with the clerks and asking this scenario, I think that's a better word than hypothetical, but is how about if the person waved around a newspaper and said, I was looking for one of the jobs that was listed in the newspaper. Anyone could do that. And that gets to the clerk's memo about proof. So basically you have a way of always being able to claim that you're a bona fide resident. And it truly is a question of what's in somebody's head. I mean, it gets to your point earlier about, is it within the bandwidth of something that's going to be prosecuted when you were talking about the poll watcher intimidation? And I would argue it would never happen. And if it did, it wouldn't be something that you could take to the finish line because it's a question of what's in your head. Now, 30 days is not. It is an objective question. Have you been a bona fide resident for 30 days? It's a durational aspect. That's why we always try to emphasize, we've been trying to do that from the start. This is a durational residency requirement, different from a residency requirement, durational.
Mr.
Thank you.
Mr. Co-Chairman.
So if we can disagree about what bona fide means and say that's in your head, and it can be in your head for an instant, can be in your head for a day, or it could be in your head for 30 days. I'm not sure that it changes the underlying intent and the bonification, if that's a word.
Mr. Chairman, appreciate that scenario. I would respectfully push back on that. I think if someone, say in the state of Georgia, said, I want to go to Wyoming, until they establish that physical presence, they are not a bona fide resident. You can't just say in Georgia or California, I look forward to moving to Wyoming and have that in your head. You have to be here. And that's why the durational aspect is very important as opposed to a residency requirement, which is in your head. So you could be here 10 seconds and have that in concert with what you're claiming is in your head, and then you're a resident. That durational residency requirement adds that extra protection, which is that physical presence, which you can't get solely from claiming you have a thought in another state and you're not a Wyomingite then.
Mr. Co-Chairman.
So, Mr. Chairman, I mean, I think they're two different things. There's the 30 days and there's the bonification. So if you said a bona fide resident and physically was in the state for 30 days, those are two things that go together and help you to come up with a result. But if you say, I've been a bona fide resident for 30 days, doesn't mean you've actually been here for 30 days. You could have been here for 10 days and been away 10 days, and then went somewhere else for 5 days and came back here. So I'm not getting exactly how A follows B.
Mr. Rubino.
Thank you, Mr. Chairman. Yeah, I don't have much to add to that, although the 30-day aspect and why other states have adopted this as a policy position is that it increases that sort of investment in Wyoming. You're returning to somewhere. So just because you're not physically present, it's the intent to return. Returning to where? Returning to your home state. That's sort of where it's getting at. So yeah, right now it could be as little as a day that you intend to return. Obviously, that raises some questions about what could be incentivized because of that.
But Mr. Chairman,
But Mr. Chairman, I'm
Yes.
sorry, Mr. Secretary. The oath, I come down to the oath. That I'm a citizen of the United States, that I'm a bona fide resident of the state of Wyoming and this country or county. And then the next affirmation is I have resided in the state for not less than 30 days before the date of the election. So does that mean that you came here 30 days ago? You got that hotel room. Then you left and went to take another job and come back. Are you still, have you resided for 30 days? So, you know, if you could say I have physically resided wholly within Wyoming for 30 days before the date, I get it. Then that seems to add to the bonification, but it doesn't allow for that now.
Mr. Secretary.
well, Mr. Chairman, I would note again that this gets to the definition of residency, which is already in statute. So I mean, but you have that durational aspect there. I think it's a question we want to engage in, but I would say that once you sever that hotel room, you haven't established the durational aspect. So even if you have the intent to return, that could be problematic. Now, if you have a fixed place, okay. But then, it's a complex question, but it would need to aggregate.
Yeah, I'm just worried, Mr. Chairman, that saying you've resided for 30 days doesn't really say much more than that you're a bona fide resident.
Well,
Both have this quirky murkiness to them, and putting two quirky murky things together doesn't fix it for me.
well, Mr. Chairman, I would push back on that. I think it does add strength there. I think right now it's a huge hole in our statute, and putting that 30 days there, I think is better than status quo, which is total silence on this question of a durational aspect. So.
All right, shall we hear from the clerks?
You bet.
Thank you, Mr. Secretary. Thank you, Mr. Rubino.
Does anybody need coffee? You need coffee? No, I'm good.
Welcome. In the interest of time, hopefully you're not going to read us your 13-page memo.
Mr. Chairman, word for word. My name is Malcolm Irvin. I'm the Platte County Clerk, and I have the honor of serving as the president of the County Clerks Association. To my left is Julie Fries. She's the Fremont County Clerk. To my right, Deborah Lee, the Laramie County Clerk, and Gwen Bartlett, the Carbon County Clerk. I'd just like to start by saying thank you, Mr. Chairman, not only to this committee, but to LSO. We were very late in getting this memo to you, and I really appreciate your flexibility and your willingness to include it in the material. So thank you to both the committee and to LSO. Really, the purpose of our memo is to highlight that there are two issues. The first being the lack of clarity. The reason we put it first is because that's the one that has impacted us the greatest. And number two is the durational residency that you're considering today. As always, we want to make very clear that we have no policy position on the question of durational residency. However, durational residency can be administered and is currently being administered in 4 states who have National Voter Registration Act exemptions. The reason we chose it to compare it to those states had same-day registrations and NVRA exemptions. And so that's why we felt we were comparing apples to apples with those states. Mr. Chairman, really our memo says it all, and primarily we'll be here to answer questions, but I do want to highlight that on page 2, we say, we believe that these are two distinct matters to be considered, but admit that without addressing the broader issue of residency, a durational standard will have the same enforcement effect as the current residency standard. That really is in there not to convolute the issue or make it murky, but to let you know that the issue that exists currently with residency will continue to exist even with a durational requirement. But again, the durational requirement could be administered. We would essentially administer it the same way that we do currently. The second half of the memo, where we compare ourselves to the other states with NVRA exemptions and election day registration, is really just to prime the pump in the event that this does pass, that we would be able to work through the actual documentation issues and the what we would require to really prove the veracity of their claim. Mr. Chairman, before I end, I would like to read probably the most important paragraph, at least we see it as the most important paragraph, which is on page 1, it's paragraph 2, which says, often county clerks get the brunt of accusations when citizens believe some individuals are misrepresenting themselves as Wyoming residents. For instance, the presence of vehicles with out-of-state license plates at polling places has caused some to call into question the process by which county clerks validate a person's residence, specifically on election day. In reality, the definition of bona fide resident of Wyoming is vague and difficult to definitively prove given current requirements. CCAW's concern is that certain individuals believe the clerk and election staff are responsible for requiring proof of residence at the time of registration. However, this assumption is not supported by the election code. Being the target of these concerns and accusations has heightened our sensitivity to the vague definition of bona fide resident, which is present in Wyoming and many other states' election codes. And so, Mr. Chairman, I'd be remiss if I didn't read that portion, because we want to make that very clear, that we face the brunt of the accusations when somebody believes we are not doing our job, when in fact we believe we are following the election code and rules as they're currently written. And I really messed up by not giving credit where credit's due. 90% of the work that went into this memo was done by Deborah Lee. And so I just want to say thank you to Clerk Lee and her excellent work on preparing it. I just get the privilege of presenting it. She actually did the hard work. So thank you, Deborah. And to answer one of the questions that was asked and then brought up by Secretary Gray, we do believe that the residency requirements, the proof thereof, should be in rule. We state that in our memo. They're currently in Chapter 3 rules, and we believe that's where they should be. So, Mr. Chairman, the county clerks would stand for any questions.
Senator Boner.
Thank you, Mr. Chairman. So just to be very clear, in terms of the bill draft we have before us, you would be able to administer this. Or maybe put another way, this wouldn't cause any problems in the 2024 election if we pass this bill as is. Is that correct?
Mr. Chairman, the only things that we had on the bill itself were the effective date that of July 1, 2024. Our request would that it would be effective immediately. If July 1, 2024, we're in the throes of UOCAVA and absentee voting, so that would be problematic. The only other question we had was brought up by Clerk Bartlett. It's page 4, line 16, but it's really lines 14 through 16, which is that they've resided in this state for not less than 30 days before the date of the election. Is the election day, November, in 2023, election day is November 7th. If somebody moves into Platte County on October 8th, absentee voting begins on October 10th this year. Does that person who requests an absentee ballot on October 8th, they're swearing that they have resided 30 days before the date of the election, is that election date November 7th, or is it the day that they obtain their absentee ballot? That would really be just clarification and intent from the committee that I think would help guide us to make sure that we were administering it the way it was intended to be administered.
Hey, Senator Boner.
And follow up, and I appreciate the memo, and I think maybe perhaps would you agree that's something we could take up not this interim, but maybe the next interim. Because that seems a little bit more complicated and maybe not advisable to delve into, have that act be effective maybe a couple months before the election starts. Would that be an accurate statement?
Mr. Chairman, I'm not completely sure I understand Senator Boner's question. Which portion could be clarified in the next interim? The reason I say that is if this bill draft were to pass in the next session, our questions would still remain about the election. So I'm not sure, Mr. Chairman, if I completely understand which portion Senator Boner is asking if it could be clarified in a future interim.
Senator?
Well, just exactly what you brought up with, the enforceability of the 30-day residency requirement. If that's what we end up doing. Also, the definition of residence and cleaning that up. Seems to me that requires quite a bit more careful consideration. And may even be slightly separate, though related to this bill draft we have before us. So, and as you say, maybe that's something you address through rule. So just want to make sure we aren't mixing concepts here with something that needs to be addressed, but perhaps could be addressed later in the bill draft we have before us. Make sure that it seems like there could be some distinction there.
Mr. Chairman, if this were to pass as is, we would continue to administer voter registration the way we do currently. The only difference would be a part of the oath would change. They'd be swearing to that effect. The enforceability aspect would still be the same as it is today, which is by complaint process. And so if somebody complains and says, well, I don't believe Senator Boner has been a resident for more than 30 days, then we would forward that complaint on to the sheriff for investigation. And I think page 2, the first line of our second paragraph really says it. We believe that these are two distinct matters to be considered, but admit without addressing the broader issue of residency, a durational standard will have the same enforcement effect as the current residency standard. So the answer, Mr. Chairman, I took a long time to say it, would be yes. We could address our first concern in a later interim, later session, if we have the understanding that the way we conduct would not really change. And so our concern where we're getting the brunt of accusations when people see out-of-state license plates at a polling place and are accusing us of shirking our duties, we would still be administering voter registration the way we do today. Is that the longest yes in recorded history?
It's Senator Scott.
Mr. Chairman, I've been sort of sitting here flipping a mental nickel on this bill. And general principle of legislation is if it ain't broke, don't fix it. And I don't see any evidence that we've had real problems in this area. I do think maybe the 30-day durational thing would stop a potential abuse if, say, we had particularly a hot primary election for an office like U.S. Senate. I think we're a little open to an organized campaign in one of our neighboring states to move a bunch of people very temporarily to Wyoming to vote in that election and have them disappear the day after the election. I think this could be used to put a stop to that. But it also seems to me that we may be seeing evolve a standard practice of a 30-day residency requirement right across the country, with provision that was read earlier that allows people to vote in the state they're leaving if they haven't had time to qualify. That may be a workable national system. My question is, are you seeing, talking to election officials in other states, are you seeing any movement to everybody going to a 30-day national requirement or not? And do you think that having this would prevent an organized effort to move people into Wyoming to vote in our election?
Mr. Chairman, I would actually defer that question to Clerk Lee, who, like I said, did the majority of the research on this. Whether it's being considered in multiple states, that is something I would toss. Sorry, Deborah.
Clerk Lee.
Mr. Chairman, Senator Scott. Actually, I've seen a lot of variation. It can be like 22 days, 28 days, up to 30 days. So I don't feel confident in saying that the standard is 30.
Ms. Freeze.
Julie Freeze, Fremont County Clerk. Recently, Deborah Lee and I have been appointed to the EAC's new committee of the local leadership committee. And we met recently in Washington, DC. And so the question of that did not come up. There's a lot of stuff that came up nationally. That one was not one of the issues that was talked about. One of the issues that was talked about is how can we, and this is just talk among election officials, but how can we have some method to check if you have voted across the nation so that you can, that's the gap we need to fill. So that is one area that we talked about, but that one, I just wanted to answer because we had recently been to a conference, so. And one other thing, if I could just follow up with what our president said, and I want to make it really clear. So I think it was Senator Landon that actually asked, can you give me, or somebody asked the secretary, can you walk me through an election day? So and today, or with this change, a voter comes up and they fill out the form that says, right now I'm a bona fide resident, or in the future, I've been here 30 days. They're swearing to that. We let them vote unless an election judge challenges. That's the only person who can challenge. So then let's say somebody comes to me later and goes, so-and-so shouldn't have voted and in here because they don't live here. They would file a complaint, which then now goes into for the sheriff or law enforcement of wherever the agency that area is, for them to go out and interview and find information on that, and then see if it's something they can prosecute. In my county in specific, even before we had this option, I've had where we have won cases and we have lost cases due to intent. So I just wanted to let you know that right now we're not required to look at those documents, only if they're challenged. We have in rules for them to be able to go bring these pieces of paper that are in the rules. But I just want to make sure it's very clear. Right now, we're not required to do that. We would not be required to do that with a change in this current bill. Just want to be very clear because I know in Lander, it was not clear. So I just want to make sure we're very clear on that. Okay. Thank you.
Senator Barlow? No. Representative Yin?
Mr. Chairman, thank you. Clerks, thanks for being here as always. Secretary Gray said that this would make it so the hypothetical situation of a person in hotel could be prosecutable. Would this durational resident, and then I think Malcolm, Clerk Irving, you said that it wouldn't change the enforceability. Would this, if we pass this, would there be cases where you think that we would win in prosecution, even though we still have to prove that intent portion of having to return that we've all been kind of talking circles around?
Mr. Chairman, I apologize, but I left my crystal ball at home, so I would hate to speculate. But I guess the point I would make is right now, I think complaints about residency are few and far between. If my colleagues have seen differently, I'd love for them to interject, but we all have them. They're just few and far between when you compare the total number of voters throughout the county and then the number of complaints as they relate to residency. And so in those complaints, and I'm going to speak specifically about Platte County, where I had one where the county attorney's advice was cancel their registration, have them register at the new place. They were still a resident of the county, just reporting to be in the wrong precinct so that they could vote on municipal offices. And so the advice was, let's not worry about prosecution. Let's worry about just getting it right going forward. And so that's an anecdotal, a single case from Platte County. And one thing we were remiss in saying was we are glad, I think is the right word, that this bill draft, if it was to move forward, is a residence durational requirement for the state and not for the precinct itself. I think that would be a more significant and problematic issue. So thank you to LSO that in this draft, it did not contain within the precinct. So I know that doesn't answer the question, Representative Yin, but it is hard to speculate wins and losses. I think Clerk Freeze really highlighted that it can go either way.
Representative Yin.
So thank you, Mr. Chairman. Clerks, I mean, one thing that you did mention is that it is a complaint that is few and far between. Would you consider this a problem in Wyoming?
Mr. Chairman, I think the way we see it, and again, we don't want to weigh in on the policy question of it, whether it's a problem, the problem we see is that we're often the ones that get the accusation that we're doing something wrong. I think that's where we identify the problem. And it's a metric that's honestly impossible to track because it's not something we're tracking, is how long somebody has been a resident of Wyoming or what documentation they're proving if they are challenged. It's just not something we track. So it would be hard to say whether it is a problem, but if the complaint process was an indication, we get few complaints for specific residency questions, if that answers.
Representative Newsom.
Thank you, Mr. Chairman. I have a question concerning the precinct thing. So as I read on page 4 of the bill draft, the affidavit piece, and then it says, I do solemnly swear that I am a citizen of the United States, that I am a bona fide resident of the state of Wyoming and this county. And then goes on with the inserted language of I have resided in the state for not less than 30 days. And then goes on to say if registered in another county or state. So would it be reasonable to add to the inserted language that there have been a resident of the county? Or are we not at all concerned about county residency? We're only concerned that they're a resident of the state and not at all concerned that they have been a resident of the county for that duration of time. Thank you.
Mr. Chairman, I think that the way the language is on page 4, again, we're just asking for the clarity on the election as it relates to absentee balloting. Originally, when we walked away from the first interim committee, we just expected that the bill draft would insert on page 14 or on line 14, excuse me. I'm a bona fide line 13. I have been a bona fide resident of the state for 30 days in the county. I actually think there's a lot of wisdom in adding an additional clause that's outside of that. So it's just specific to the state and not the county itself. So I think that was actually a good place for it, for administration to make it clear to us that our intent is that we're concerned that they're a resident of the state for 30 days.
All right, Senator Landon.
So, thank you, Mr. Chairman. Really appreciate all 4 of you being here. And this is a question for any one of you that might help us with this. If we pass this bill and it moves on, ultimately passes through the session, does it compound in any way that election day that you alluded to? I'm looking at Ms. Breeze, and your ability to execute the elections with your staff, your volunteers. Talk to me about what this bill does with boots on the ground.
Clerk Freeze.
One thing to put it in the statutes, Mr. Chairman, but
yeah,
I'm just curious, what's it going to do to us on election day?
Clerk Freeze.
Mr. Chairman, Senator Landon. So as I mentioned before, currently, and if this passed, I come to register, I'm going to fill out an oath swearing to that. And unless that election judge has some real positive feeling, I mean, because when you train them, you're not going to just guess at this stuff. You're not. I mean, and they could do that and they could get a provisional ballot. That takes time. But generally, it's going to run through the same way. You're just swearing, just like you are, I'm not a felon, which we prosecute. I'm 18 years of age. I'm a US citizen, which we prosecute. I mean, not we prosecute, but we send them on for that. So it's no different than that. I'm just swearing that I've been here for 30 days. And the only thing I would add to the 30 days within the county or the state is that's something you guys need to consider. And maybe there's public comment that will tell you the answer to your question. Where in the election process does that matter to people? If it's just the state and I can move all over in the county and it doesn't matter, and an election is decided by one vote or it's a tie and we're flipping the coin and somebody loses and somebody wins, that's what you guys have to decide. Is that it does increase some other things. And at this point, you may say it's fine, and maybe it is, but I'm just saying maybe there's somebody out there that would go, wow, I don't want them in the municipalities. You brought that up, the municipalities. I don't want this person who, oh, I've just happened to be here, but I'm in the state 30 days or the county 30 days. That's something you need to consider. And our document, seriously, we talked about it a lot. It's just educational for you. And the work that Deborah Lee did and that we discussed is we've had several legislators try to do this on the floor and pull us out and try to work with us. And we're going, you can't do this in like this much. It takes a full year of study. And we've at least gotten this far where it's at least in the interim to at least talk about that. So it's a complex issue still. And those are things you guys will have to just determine, and your full body of the legislature will have to determine. Thank you.
Thank you, Mr. Chairman. Thank you.
All right. We'll take a couple more questions, but we really do need to move forward, guys. Just as a reference point, you have 6 more bills to go. And from this point, if you averaged anything more than 20 minutes per bill, we'll be here all night. So just a heat of caution that there's a point where you can beat the horse to death. Yeah, it's dead. Representative Knapp, you're not going to heed the caution.
Mr. Chairman, just have one.
Mr. Chairman, I just had one question surrounding if there's a challenge or an audit after the fact in election, would this become a factor, or could this affidavit basically, or this oath that you signed, become a factor in that instance?
Mr. Chairman, Representative Knapp, just the way that voter registration is currently. And so we would conduct it the same way that we do currently. And again, just as a reminder on page 2, we do say there are 2 distinct matters, the lack of clarity in residency itself and the durational aspect. And so we just offered the first point, the lack of clarity, so that, and Mr. Rubino in a meeting we had put it probably the best I heard, that conversation and the problem will exist prior to durational residency. And if it passes after durational residency, it will be something we have to continuously work on as we move forward. But Representative Knapp, if there was a challenge, it would be the exact same way we do it now, which is complaint basis and forward to the sheriff for investigation. But it would have to be a specific complaint, not a generalized complaint that, well, we think that you had people come in and register. No, the complaint would have to be, we believe person X came in and registered, but they're not a bona fide resident.
All right.
Thank you all.
Thank you, clerks.
Love the clerks, don't you?
Always appreciate your help. Do we have any public testimony online? If we do, go ahead and raise your little hand so we can let you in. How about public testimony in the room? Yes, sir. Come on up.
See if you can find one.
You got
that's
it.
at work.
Push the button. You got to
The
push
one
the
on
button.
Center. Got it. Okay. I'm going to be brief because I know you got a lot of bills. My name is Ross Schriftman. I live in Casper. Senator Case, you made a good point, Mr. Chairman, members of committee. Thank you for your work. I believe your comment was, or your question was, what happens to the voter registration of the individual that moves from one state to another? I want to give you a quick example of me. I moved to Casper in June of 2021. And after I got settled into my new house, I went to the voter services at the county courthouse. I registered to vote. I was informed that Pennsylvania would be notified that I'm registered here. In September, Pennsylvania still had me registered to vote at my old address. So I contacted the voter services office and the director told me, oh, well, you have to fill out a request to remove your name. I've been in politics since I was 13 and I'm 70 years old now. I have never heard of that. So I asked, well, how many people fill this out? And she told me, I can't tell you that. You have to fill out a FOIA request. Okay. 2 months later, yes, 2 months later, the Montgomery County solicitor sent me a letter saying they cannot give me that information because it's voter information. I was asking for one number. How many people fill out this form? Nobody knows about this form. Okay. The reason was not only that I'm not entitled to it, but I'm not a Pennsylvania voter anymore. Weird. So then I went back to Natrona County Courthouse and talked to voter service staff. And I said, well, how many people did you remove last year? And they gave me a number. Okay. First of all, they do a great job in Natrona County. They're great. They're really good. So the issue is that there are hundreds of thousands of people that are registered in 2 states, and most of them have no clue that they're registered. Now, that's not a problem unless somebody votes your vote. Now, there are some people with intent to vote in 2 states, and there are examples of that. That happens. As a Heritage Foundation has a sample listing of that. But Pennsylvania had a court case, I believe it was a court case that removed voter ID. At the 2020 election, a week or 2 before the election, the Secretary of State told the clerks that the workers could not check signatures. So I observed as a poll watcher, people coming in, getting handed a ballot, signing the registration, no voter ID. And then I found out that people around the state went to the polls and were being told they had already voted and voted on a provisional ballot. Now, which ballot counted, I have no clue. So that's not a problem here in Wyoming because we have voter ID. So I just wanted to bring that up. It's not directly related to the legislation that you're looking at, but to answer Senator Case's question, that does happen. We do a better job here. We can always do better. Thank you.
Thank you, sir, for your comments. Representative Yin.
Just one question. Thank you, Mr. Chairman. Welcome to Wyoming in 2021. If you had moved in an election year in October, would you prefer to have voted in Wyoming elections or in Pennsylvania elections?
Well, it wouldn't have been, Mr.
Yeah.
Chairman, Representative Yin, it wouldn't have been, I would have found out if that happened, and it almost did happen because I had my house up for sale and I had a buyer, and the last minute, the mortgage company for the buyer wanted another inspection, like 3 weeks before I moved here. So it could have happened that I could have been in a situation. I would have checked with the voter services to see which state I would have been eligible to vote. And if I'd already moved in and Wyoming had this 30-day requirement, then I would have sent in an absentee ballot in time to vote.
Representative Yin.
Yeah, Mr. Chairman, that wasn't my question. My question was, where would you prefer to have voted in?
Mr. Chairman, Representative Yin, where I'm entitled to vote. I would not vote in any election which I'm not entitled to vote in. And that is, I think, the problem that's trying to be addressed here is where an election takes place in another state or another jurisdiction where people are deciding which one I want to vote in. That's not the way our system is supposed to work. We're supposed to vote in the election where we're eligible to vote.
All right. Thank you, sir.
Thank you.
Gail?
Gail Simmons, Civics 307. And I sent out a presentation. It's just one page. A couple of things that I want to point out. I don't want to go too much into the details. You've got lots. Is this page uses registration data as a proxy for residency, because we don't have data on that, but we do have data on registration date, effective registration date. This whole thing needs to be, Mr. Chairman, this whole thing seems to be coming out of concerns about election integrity. And so it addresses the latest election fraud claims, which is that people are swooping in from outside to commit fraud and then bailing out of the state, right? They want to influence the course of the elections. And on a side note, we have one or more what I would call snake oil salesmen peddling fear of fraud through this within the state without any data or facts to back it up, which is why I am providing this. I'd like to speak just a moment on risk management theory. And we did this extensively at a large business I worked on. It is first, what is the risk? You identify what the risk is, and then you identify three factors. What is the probability of occurrence? What is the detectability that it has happened or could happen? And what is the severity of the result or the outcome? And when you evaluate each risk on those three factors, you can then prioritize and identify risk abatement appropriate to the combined scoring. So the first question should always be, what is the risk? And define the risk and identify what it is. And this is really, if you dig under people voting who shouldn't be able to vote here, it's really around, are they impacting the outcome of the elections? It's kind of like when you ask somebody what's really important and they say, well, it's really not, it's not the money when I'm suing. Yeah, it is. You want the money. And it's the same thing here. It's the outcome. So what I've got here, and I just did it for the primary, the results are somewhat similar for the general, but what you see is this is all of the individuals who were ever registered in WyoReg for the entire state of, or entire year of 2022. Only 5.4% of them registered within the same year, and less than 2% registered in the 30 days prior. So these are all the ones that were registered prior to, what was it, 16 August 2022. So then I wanted to take a look at what you see is for those last minute ones on the upper right, the gray. Did they vote in just the primary? Did they vote in just the general, or did they vote in both? And incredibly, the last minute registrants, 85% of the time voted in both elections. So if they flew in, got a hotel room, and then left, then they turned around and they flew back in, got another hotel room, and voted again. And I want to draw your attention to the lower left, because they then remained registered. So the question is, what is the risk? So if you see the people who did not vote, these are the ones who were registered prior. We had 30% of registered prior who did not vote. And the numbers on that, by the way, far exceed the number of people who came in and registered. So what you see is those that were greater than 30 days, they voted only in the primary. Well, that's pretty true for a lot of things, because whether we like it or not, 76% of the legislative seats are decided in the primaries, and 99.9% of the county seats are decided in the primary. So if you vote in the primary, why bother with the general unless you care about a school board election? And then I switched it around to vote padding by registration timing. And again, you can see the degree to which they voted both based on when they are registering. So my whole point here is that we do not have fraud. If we do have fraud, we can't document because anecdotal information and fear is no reason to write statutes. If we don't base this on fact, if we don't do risk, then what are we doing? So if the sum of this is to say, we're going to add this duration to what I attest to, and if you violate that, it's the same as as what the attest was before, which is we're going to get you for perjury, then go ahead and add it in. But we're solving a problem that we cannot define actually exists. And I stand for questions.
Representative Knapp.
Mr. Chairman. Yeah, I hear that. I hear that a lot with arguments on safeguarding elections. I think everything that we do involving voter qualification, ID status, is to safeguard that a Wyoming voter who goes to vote, their vote is not diluted by fraud. Okay, so would you, in your definition with statistics, would you say that banks should have no security measures if it's never been robbed?
Mr. Chair, I'm and Representative Knapp, I go back to my definition of risk management. And so again, it is probability, detectability, and severity. And so the severity of a bank being robbed is significantly different than the severity of one person slipping through somehow and casting one vote in an election. Because except for several years ago, I think in Lincoln County, we've not had elections that were determined by one vote. So the severity of the outcome is where there's a difference there. And I'm not saying we shouldn't have precautions. I'm saying we need to work off of facts, not fears that are generated out of whole cloth. Thank you.
All right, thank you. Mr. Odom.
Thank you, Mr. Chairman. Don Odom, Cheyenne resident and Wyoming State Director for the Restore Liberty organization. I've been hearing a lot of whys we should have this, and my reasoning is legitimate and fraud-free elections are the foundation of our republic. And even if we do not have any documented cases of that happening in Wyoming, we need to take every precaution to be sure that they don't start. And as a resident oil field worker that moved here from Alabama, I'm pretty familiar with these issues. And excuse me, I took my notes on my phone, but my vision's not that great. I believe our right to vote is one of the most important things about our country, and I'm sure everyone agrees on that. When I moved here to Wyoming a few years back, I'm a outdoorsman. I love hunting and fishing. I had to wait a year to be able to enjoy doing that or pay the, high dollar non-resident license fee, of course. When I went to get my license, I had to present mail that had my address on it, and there were several different versions that would be accepted. A utility bill was one. I don't remember the others. And I also had to present a Wyoming driver's license. So I believe that the right to vote in our state is more important than hunting and fishing. It's just a little bit for me, but it's more important. And I don't see anything wrong with tightening this up to be sure that we are being sure this type of fraud doesn't happen. As far as people moving at the last minute, that's part of your individual responsibility as an American. Now, sadly, there's not a lot of talk about individual responsibility these days in our country, but it does and should still exist. And especially here in Wyoming, I believe more people would agree with that than a lot of other states. As far as the issue with a new resident with less than 30 days in the state being able to vote in a presidential election, when I go to my polling place and they give me a ballot, it or in our case, the machines, we have a card that we put in there. When the ballot comes up on that screen, it shows me what my choices are based on my address. Some representatives I can't vote for because I don't live in their district. I don't see where it would be very hard to code the ballots that if a person came in and was found to be a short-term resident, that the ballot would just show the presidential election and that would be it. Any questions?
Committee questions for Mr. Odom? All right, thank you, Mr. Odom.
Thank you, Mr. Chairman.
Did we have anyone online? No one online? Okay, anyone else in the room? Ma'am. Welcome.
Good morning. I'll make this quick because probably like a lot of you, I'd like to get back to Gillette and watch my grandson's football game that is at 8 o'clock tonight. Do you think we can be done by then? So Patricia Junick, Campbell County. And I just want to address that I was one who traveled around the state with the snake oil salesman. So there you go. And we met with a lot of clerks along that way. And we disagreed on a lot of things, but there was one thing that we absolutely all agreed on, and that was the residency requirement. Every single clerk we spoke to said that is the huge issue. I don't know if I can say it's the number one issue for them, but they did say that is a big issue. And you talk about, is it an issue yet? What is the problem with being proactive and not reactive? And then also the risk. What is the risk of not passing this bill versus the risk of passing this? And another thing about it is, you know, what can it do? And the clerks talked about, they're still going to do everything the way they've been doing it. And then but it does give them meat to prosecute. That's what it does. And last thing, I'm from Washington State. I'm so thankful God moved me to Wyoming almost 10 years ago. Thank you, thank you. Much rather be in this state. But you know, if you pay any attention to Washington State or any of the other states, there are a lot of problems. And would I like to go back and vote on some of the issues they've got going on in Washington State? Oh my goodness, yes. But I don't live there. I grew up there, lived 55 years there. Doesn't matter. I live in Wyoming. So why do we want people from other states coming and voting in Wyoming? Stop it. All my relatives are there. I could go back there and I could register and I could put down their address. Who's to say I couldn't? It's not right. So that's all I have to say.
Committee, Mr. Co-Chairman.
Thank you very much, Mr. Chairman, and thank you, ma'am, for your testimony. I'm having a little bit of a trouble, though, with the reconciliation of it. And the reason is I don't think the new language makes it slam dunk to prosecute it at all. I don't think it makes it any much better than it is now. It comes down to that oath. And before we argued about a bona fide resident, now we're going to argue about whether you resided for 30 days or not. I don't see that that's a lot clearer with the prosecutor or not. And I will challenge, I'd like to hear from the clerks again that, you know, I don't think that they think the residency issue is a big deal. And I've talked to several of them and I know them well. So I don't disagree with your testimony in the sense that you feel that this is going to make a big difference. I don't see how this can make a big difference. And we're going to disagree on that, I suspect. Thank you.
Thank you.
Representative Yin.
Thank you, Mr. Chairman. Ms. Junick. So, I mean, the bill that we're talking about is actually about depriving a subset of new residents that move here a month before an election from the ability to vote in Wyoming elections. It's literally depriving them of that right, as Mr. Odom mentioned, of the right to vote in the state of Wyoming. If they don't have that escape clause, then maybe they can figure out how to argue about a provisional ballot of absentee in their previous state. But we're literally talking about, is the cost of depriving these people who aren't going to be able to testify because they don't know that they're going to move here yet, so they can't come testify us, but maybe eventually they'll be constituents, that they cannot vote a month before the election, even though that they are new residents, bona fide residents of Wyoming. The question is whether it's worth that deprivation of that right to allow the potential prosecution of folks who are going to commit perjury, essentially, to lie about being a resident of Wyoming. So I guess the question is, do you think that the amount of fraud that we're going to find if we pass this bill is worth depriving those folks of the right who just moved to Wyoming to vote in Wyoming elections now that they want this to be their home, as you did when you moved here, or as Mr. Odom did, or as anyone else who has moved to Wyoming has done?
Ms. Junick.
I'm not sure I'm going to actually want to address that, if that's okay. I think that's a spot for the Secretary of State's office to address and the legal office to address. But my position is I support this bill.
All right, thank you, Ms. Junick. Thank you. Any other public testimony? All right, seeing none, I will close public.
Is there any chance I can get a second bite?
Absolutely not. Okay. Is it, yeah. You do? Okay, let's grab that one person first, then we'll go to you, Mr. Secretary. Yep, go ahead and let him in. Welcome, Miss Davis. Miss Davis, can you hear us?
Yes, can you hear me as well?
Now we can hear you.
Thank you for the opportunity to speak.
We can't see you. We don't know if that's intentional or not.
No, I just found my start the video, so.
Now we can see you.
Yeah, okay. So I so appreciate this issue being brought forward, allowing integrity to our election process. So I think the gentleman who spoke on licensure to hunt or fish said it very well. Like, there should be an investment in Wyoming. And I think we all know people who come and who go. And those people have value. And those people have a say. And but should they say in our elections who could be there or who not? I'd find 30 days as minimal, a very minimal requirement for someone to be here. Like, my father would come stay for 30 days. You know what I mean? But should he choose who our representative is? Like, we really have to consider that. We say deprive rights, but we have to respect rights and the rights of the people who are committed to the state of Wyoming. And so I just think to not safeguard our elections is like an invitation. And so people told me before that to not lock things, or rather we do lock things to keep honest people honest, right? Because a crook is going to beat down the door anyhow. A crook is going to falsify information. He's going to create an ID. He's going to use the hotel as a residence, whatever he's going to do. But to keep honest people honest, there should be some safeguards in place. And to safeguard our elections, I found it interesting that we would challenge what our clerks thought. Remembering, like, I respect our clerks and I'm thankful for our clerks, but they are hired by the people. And aren't we trying to protect the people of Wyoming and what they believe in and what they stand for and who they are? Do they have a voice? So I'm standing up for the voice of people to say just 30 days. I mean, I'm in for the year, but 30 days is a start. I do stand for questions.
Questions for Ms. Davis? All right, thank you, Ms. Davis.
Thank you for your time.
Mr. Secretary.
Well, thank you, Mr. Chairman, and appreciate, I don't think it's take more than 180 seconds or so. I want to engage a little bit of discussion on this risk versus cost discussion. I think permeated some of Ms. Simmons' testimony, some of the questioning from Representative Yin, and do want to make clear that I do think there is a real risk here. And I think I differ a little bit with the clerks on this. I mean, when you think about primaries routinely that have 2,000 votes or less sometimes, I mean, I think to many that have 1,500 races are all the time decided by 3 points or less. A 3-point race with 2,000 votes is 60 votes, right? That is something that in theory could be brought in an organized effort very easily to swing in an election. And that's a House race. And I will tell you, people ask about specific examples. There's not been an election cycle where I've been Secretary of State, but I've had multiple times, and I think looking around the room where you've probably had this too, where I do receive calls that people have suspicions that people have been bussed in and they've seen a bus in a certain community and haven't investigated that. I want to be clear, but all the time you get anecdotal things like that. And a scenario like that, which I think permeated some of the comments from Senator Scott earlier, I think having this would be very useful, because if you were one of the people orchestrating that, you would just say, well, look at Wyoming statute. It's not really illegal the way it's worded right now. If you're in a hotel, maybe the scheme arguably could be, but my conversation with the clerks, it's questionable. And I think having that 30-day element, I always go back to my conversation with law enforcement, 95% more than that. I think having that in the oath is going to stop them from doing that, even if it's someone engaging in a potential scheme, busing, something where someone's being moved in from another jurisdiction or something. So I think, I mean, and on this election stuff, I just go back to voter ID. I'm fascinated by people who say, well, until there's an issue that is 100% documented, well, in a race that's decided by 60 votes or less, you want an issue that puts the whole election in doubt? I mean, you got to be proactive on things across the board, but I think specifically this one, where, I mean, you have some sort of scheme, that scenario I was talking about earlier, very easily could throw the entire election in doubt. And it's very difficult to identify once they're in the system what votes were cast by those that were potentially moved from another jurisdiction. So I think that kind of gets to what I wanted to talk about. Thank you.
Senator Barlow.
Thank you, Mr. Chairman. So my question, Mr. Secretary, thank you for being here, is if this bill were to pass and passed, I think obviously would have to either apply to the subsequent election, but if it's going to apply to the 2024 election, it should pass with an immediate effective date. Would there be rulemaking required? Would your office undertake rulemaking? I think it's under Rule 3 to do anything to effectuate, or would you rely, as the clerks talked about, on current rules? Thank you, Mr. Chairman.
Mr. Secretary.
Well, Mr. Chairman, on the durational aspect, I don't think there would be any guidance. This is on durational. Now, residency is a separate question, and we're talking about the clerks on a potential few policy things on that. But on the durational aspect, no, it would be the statute. This way this is currently worded, there's nothing to define. It's 30 days. So I don't think there's anything to define really. And I do want to be clear as well. Thank you for bringing that up. That was my one other note, that effective immediately. That's very important. Well, I did not mention that earlier as well.
In terms of things to define, Mr. Secretary, what about date of the election? I mean, is my mic working? Is my mic working? What about date of election? Is that when the absentee ballots start, or is that the day of the general election or primary election?
Mr. Chairman, I think that is a very interesting point. We could engage a little more on that, but I think it's okay the way it is. I think it's the day of the election. So we now have a 28-day period. So it would be impossible to cast an early vote before. If it was 45 still, I think it would be in more question, but I think it still would work. It's before the election. Yes, that vote in theory could be cast 2 days into the beginning of the period, but I have to think a little more about that. And it is a good point. Something we want to talk about.
Mr. Rubino?
Yep, Mr. Chairman, just to add a little bit to that, when we were conducting a survey of the states that do have durational residency requirements, that is some of the language that states use. It's not 30 days at the next election. It is 30 days at which the qualified elector may offer to vote in the next election. And so that might be something that the committee could undertake to clarify that language. But there's also some questions, right, about the election. You're still voting, say, in the 2022 primary election, if you vote on August 3rd, as opposed to August 16th, which is election day. So I don't necessarily know that it's necessary, but I think that's a really good point. And that might be something that the committee and LSO want to take up as to other states. What we see in Idaho, which I think is really what ours was modeled after, what the draft language is modeled after, is that they're referring to the election that includes absentee early voting.
All right, thank you. Representative Yin.
Last one, Mr. Chairman. Secretary Gray, do you have any thoughts on the county movement question? Are you worried about people busing from Teton County to Natrona County to vote?
Mr. Chairman, I am open to adding county. I do think there are some implications there. We had discussed this question a little bit, but the testimony brought that out a little bit. I mean, I certainly would invite the committee to discuss that, and I think that's something we can continue to discuss. I'm okay with state. I think I'm in a little bit of a different place. I think from I want something a little stronger, but I'm willing to get something done. We have this on voter ID. I think we get something done and strengthen this huge hole we have in our statute. And so I've been there in your shoes and want to get something done. So the state is a little bit weaker, but I would prefer county, but would certainly not want it to jeopardize the entire effort. I would not. I don't like talking about that scenario earlier. I decided not to put it in my initial comments because it talks about a blatant hole in our statute. But, when people start saying, well, there's no issue here, I feel the need to talk about where it could very easily become an issue. And there's a huge hole in terms of deterrent right now. So, yeah, thank you.
All right, thank you, Mr. Secretary. With that, I will close public comment. Committee, do you have a pleasure? Okay, the bill's been moved by Representative Ottman and seconded by Senator Boner. Discussion on to move the bill forward to this is a draft, so we would be moving the bill forward.
Mr. Chairman, I think the original motion should be, if we're going to finish this bill today, it would be good to get rid of some bills. Believe me, there's a lot of them. You don't want to carry them all to the next meeting. Or whether we are moving this draft along.
That's exactly my question. Yeah.
Yeah.
What was the intent of your motion, to make this a final vote?
Mr. Chairman, my motion is to vote for this, to make it a bill.
To make it a final bill?
Yep.
Okay.
Mr. Chairman, we couldn't hear down here. So was that a motion to carry this to the session as
Yep,
a
exactly.
corporation's sponsored?
I don't know why my mic, I just have to bring it closer. All right, thank you. Yeah, the motion is to advance the bill to the session. Senator Boner?
Thank you, Mr. Chairman. It's my understanding, of course, it's your committee, you can run how you want, but if after we have some discussion, we can always move it to the next meeting if we feel it's necessary. We need some technical changes or whatever it may be. So don't want to preclude that possibility if that's what we end up doing. But Mr. Chairman, I'll move that we amend the effective date to effective immediately in the bill.
Okay. Seconded by Senator Barlow. Any discussion on that amendment? All those in favor signify by saying aye. Any opposed? Okay, that amendment carries. Are there additional amendments to this bill? Discussion on this bill. Senator Boner.
Mr. Chairman, forgive me if this, I will take a crack at the attempt to define what exact date it is considering a 28-day early voting period. And maybe this is more conceptual, but I'll try to be as specific as possible. But in all the new language, I could go through and do page and line if you'd like, but perhaps it would work if we struck election and insert date. So it reads, say on page 2, lines 11 through 13, has been a bona fide resident of the Wyoming for not less than 30 days before the date at which he may offer to vote. And so that'd be my offer to help clarify. So in this instance, if you voted 2 weeks early, not at the election day, but you voted when the clerk's office say and voted 2 weeks before the election day, you would have to have been in Wyoming at 30 days before that date. So ultimately 6 weeks before the election day, the idea being that you have to actually be there 30 days before you vote. Otherwise, if you don't, then you could, if it's 20-day early voting period, you can still bus people in 30 days before the election date, stay for 2 days and vote early. And I think that's contrary to the intent of the bill. So, and
wouldn't if it's the date at which he may offer to vote, then it would be the absentee. It would always just be the absentee date because that's the even if whether you exercise it or not, you're eligible to vote for it.
Okay, sure.
Is that your intent?
Yes.
Okay. Okay, that's been seconded by Senator Landon.
So I
I already started the discussion on it. Representative.
I've
Newsom?
just a bit of clarification. So are we changing the language to say, as example on page 2, line 7, he has been a bona fide resident of Wyoming for not less than 30 days before the date that he's offered to vote, or the date that the voting is open?
It's the striking the word election, replacing it with date. So the date at which he may offer to vote. Which would be which would be the date, the first possible date that someone could vote.
So who is going to keep track of that? Is that the clerk's duty?
It's the first possible day that anyone's eligible to vote. So it's the first day of absentee voting.
Okay.
Senator Scott.
So if somebody offers to vote on election day, he has to be there 30 days before the election day. If he offers to vote 10 days before absentee, he has to have been there 30 days on that 10th.
No, I
day
don't.
that he actually goes to vote.
No, I don't think that's the way it would work because it says at which he may offer to vote, not in which he does offer to vote, but which he may offer to vote. So I read it as the first day he's eligible to vote, which would always be the first day of absentee voting.
So that's a 60-day before the.
Yeah,
Mr. Chairman.
50.
Yeah, okay. Mr. Chairman, I think that makes it longer and likely to get us in trouble. I thought he was offering it as the day which he offers to vote. And I asked the sponsor to clarify.
Okay, Senator Boner.
Okay, Mr. Chairman, based off that feedback, I think that, like I said, maybe it's more conceptual if it's based off of when that individual goes to vote. So whatever else we need to do, so maybe strike may and change offer to offers to vote. So it reads before the date at which he offers to vote. That makes it based off of no matter when you go to vote, early or election day, you have to be there 30 days before that date. So it's not always for everybody at the beginning of early voting, it'd be before whatever date they go in to vote.
Okay, Senator Landon, you're the second.
Mr. Chairman, I'm good conceptually with where the senator's trying to go. And so my second would remain. I think it's a work in progress. I think it's a problem in the bill and if we can fix this well enough, I'm fine to move it forward. If it's not fixed, I think it's a problem. And so anyway, my second remains, I think it's worthy of our consideration. Thanks.
Co-chairman.
Thank you very much, Mr. Chairman. Totally agree that it should be when they're actually casting their ballot, and it could be absentee, it goes in a pile and it's counted later. But the actual oath, if I could go back to that for a sec, is kind of when they register to vote, isn't that right? And so that's where they say they bona fide resident for 30 days before the date of the election or before we need to change that as well. Is that included in the motion? Because that's when you register. You go in and register, you're saying, hey, when I cast my ballot, I'm going to have been here for 30 days. Well, when do they register and when are they going to cast their ballot? So if they do the 45 days early, are they getting in 30 days before the 45? It gets a little weird. So I'm trying to figure it out for you.
Senator Bonner.
Yeah, so Mr. Chairman, the intent of the amendment is the policy decision would be, say, you have to be resident for 30 days before you vote. Perhaps the best path forward is to, make this conceptual amendment, and then we can push the bill to the next meeting. I'd offer that as a path forward. Because I think it is something that does need to be defined. It's, we do have that 28-day early voting period. What date exactly does that mean? And I don't see anybody offering any specific amendments, and we see the trouble we get when we try to do something specific with the bill on the fly. So I think it's hopefully the intent is clear enough, and we've discussed that enough, I think. But if we need to make it a conceptual amendment and then push it to the next meeting, that could be a path forward as well.
We'll take them one by one.
Okay.
So Senator Landon, are you okay with this being a conceptual amendment?
I'm lockstep with the senator.
All right.
Wherever that is.
Is everybody ready to vote on the conceptual amendment? Okay, all those in favor signify by saying aye.
Aye.
Any opposed? All right, that amendment does pass. LSO, do you have enough direction for that conceptual amendment? Yep. Okay.
And Mr. Chairman, just to clarify, it also includes making the oath part fit, right? Totally get that.
Yep.
Okay.
Okay, any other amendments? Mr. Chairman. Representative Wiley? Might be a sign.
Could be. Mr. Chairman, I would like to make a proposition for an amendment where we strike bona fide and replace it with primary throughout the bill. Just to clarify that up.
With primary?
Yeah, so has been a strike bona fide out of the bill and insert primary resident of Wyoming for no less than 30 days.
That kind of sounded like a break. All right, any discussion on this amendment?
Mr. Chairman.
Senator Scott?
Mr. Chairman, my question is, does that introduce a second subject into the bill? Because I think bona fide is a term we've used for years and years and years. And primary, I'm not sure we know what that means. And Mr. Chairman, I think there's sufficient opportunity for uncertainty over that to destroy the value of the bill. I think that's really a separate subject.
Mr. Co-Chairman.
I think we better have some caution about this a little bit, because where we use primary residence is a lot of places like get a hunting license, for example, or maybe whether you qualify, your house qualifies for a certain tax treatment or not. voting is 0-1. You can only vote in one place. And I think if we cloud it with this partial living one place and partial living in another, I'm not sure that's helpful. Your voting is only in one place. You can have two residences and live in one place, or you can RV half the year and still get a fishing license, but I think it kind of messes it up a little bit.
All right, seeing no further discussion, all those in favor signify by saying aye.
We didn't
have a second. There wasn't a second? Oh, there was never a second. We discussed it without a second. Thank you for your patience, committee. All right, any other amendments to this bill?
Question on
Mr. Chairman, just some clarification,
discussion.
please. Mr. Chairman, so on Senator Boner's amendment, where he offered to have it discussed at the next meeting, are we actually doing that, or is
No.
we're just right now the motion on the floor?
Thank you for reminding me. We're back to the original motion, which was made by Representative Ottman. And the original motion is to advance the bill to the session.
Should we put it to next meeting?
That's what motion. Unless you would like to amend your motion, Representative Ottman.
Well, we can't have a
Nope. Okay, Senator
point of
Scott.
order.
Yeah,
We have a conceptual amendment floating around that the committee hasn't seen. And how are we going to take a final vote on a bill that we haven't seen the conceptual amendment?
well, we do that. We do. I'm not necessarily saying that's a good strategy, but we do it all the time.
I don't think it's a good idea.
Mr. Chairman,
Senator Scott.
I move we carry this bill forward to the next meeting.
Second.
It's motion to table takes precedence
Is that a motion to table
Mr. Chairman,
to the next meeting.
to the next meeting?
Pepper's
Okay.
motion still holds, so we have to vote on Pepper's motion.
I don't think so. I think a
No.
motion to table is, there's no discussion on a motion to table and it does take precedence. So the bill is tabled
Well, we got to vote.
and
We haven't voted yet on the tabling motion.
almost 2.5 hours to get to that point. Yeah, Senator. I'm sorry,
Oh, did
Senator
we-
Barlow.
Did we vote on the table?
Mr. Chairman, just, I think for the clarity of the public who's listening in and maybe even some of them, would you clarify what actually just occurred so the public knows what they can expect at the next meeting with regard to this issue? Thank you, Mr. Chairman.
Yeah, and so to the committee and to the public, the bill has been tabled to a time certain, and that time certain is our next meeting. So the bill we'll see the bill again at our next meeting. It will have the conceptual amendment no longer conceptual, but actually inside the bill. And we'll continue. We'll have public comment on the bill again, and then we'll be able to have a final vote if the bill is motioned to advance to the session.
Mr. Chairman.
Senator
we
Scott.
Vote on the motion.
We should vote on the motion to table. All those in favor signify by saying aye.
Aye.
Any opposed?
No.
Okay, that motion does pass. All right. Yep, let's take a 15-minute break. Committee, let's make our way back to our seats so we can get going. Are we live? Yep, perfect. All right, we are back. Committee, just a friendly reminder, you've probably figured it out, but we have 6 more bills to go. And it's 11:15. We have a lunch scheduled for 12. We'll probably see how far we can work. Maybe we do have an hour and a half lunch, so maybe we'll work till 12:30. It just depends on where the bills are and where we're at for a stopping time, but that might be an idea, just cutting our lunch only 30 minutes short if we have to. So the next bill for our consideration is 24 LSO 0092, prohibition on private funds for conducting elections. And we have Mr. Plum. Go ahead.
Thank you, Mr. Chairman. Luke Plum, LSO. As you mentioned, this is 24 LSO -0092. This one is prohibiting private funds for conducting elections. It's creating a new statutory section, Wyoming Statute 22-123. And what it does is it just essentially says that, any government official or election official essentially is prohibited from soliciting, taking, or otherwise accepting any contribution, donation, or any funds or anything of value for purposes of conducting an election. Specifically, that all costs and expenses related to elections shall be paid with public funds. There is a exception in subsection A that it shall not apply to meals or food that are provided or donated in support of election training or education, and then meals or food provided on election day to poll workers or other election staff. Subsection B on line 12 of page 2 just says that, nothing in this section shall be construed to say that you can't take federal funds, to pay for elections. And then subsection C on line 16 it just creates a felony offense for anyone who violates subsection A, who would take funds, that it would be a felony punishable by not more than 5 years imprisonment, a fine of $10,000, or both. And this act is also effective on July 1st, 2024. With that, I take any questions.
Questions for Mr. Plum. Senator Barlow.
Thank you, Mr. Chairman. So I'm going to be clear. The way I read subsection C is it only applies to the government official or the election official. It doesn't actually apply to the person who may have offered the funds. Is that accurate? Thank you, Mr. Chairman.
Mr. Plum.
Mr. Chairman, Senator Barlow, yes, I think that would be a fair reading, that it would be, it specifically prohibits government officials or election officials from doing that.
Additional questions for Mr. Plum? All right, thank you, Mr. Plum. Public comment. Clerks and Secretary of State. Welcome back, Mr. Secretary.
Yes. Thank you. Well, for the record, my name is Chuck Gray, and I'm joined by Joe Rubino to our left, who's our policy director and counsel. I wanted to first thank you for undertaking a bill draft motion to ban private funding of election administration in Wyoming, a suggestion we made in the May meeting in Lander. I am in complete and total support of this bill. I wanted to share a few thoughts of the growing concerns I've seen around the country, as expressed to me by other secretaries of state and by citizens across the country concerning the growing need to prevent private funding of election administration. In recent years, there has been an increasing and nationwide concern when it comes to private groups funding election administration. This began with private groups funneling over $400 million to election offices in 47 states, citing COVID-19. However, many of these grants went toward massive electioneering efforts, which had nothing to do with COVID-19. Many grants contain the divulgence of election operations, and large discrepancies remain with where funds actually went. In an article by Time magazine titled, quote, "The Secret History of the Shadow Campaign That Saved the 2020 Election," unquote, author Molly Ball bragged that the election was won by a, quote, "well-funded cabal of powerful people," unquote, who worked together, quote, "behind the scenes to influence perceptions, change rules and laws, steer media coverage, and control the flow of information," unquote. These are her words, not mine. This continued in the 2022 election, with many more millions being funneled to election offices to fund election administration, making many grants contingent on quote unquote best practices and improvement plans to change election administration. These funding models are becoming quite complex and have targeted states like Utah, specifically around the ranked choice voting issue, which is also, of course, something that has been discussed in Wyoming, and some of those groups have been interested in our statutes in that matter. The source of funding for these new efforts range and include potentially foreign actors. There's a lot of discussion around this point, who as foreign nationals are otherwise prohibited from donating to elections by creating a conduit whereby the organizations they control pump hundreds of millions of dollars to advance a partisan agenda and then fund these groups seeking to influence election administration. So that this procedure creates a conduit for foreign nationals to involve themselves in election administration. In response, 25 states have banned or restricted private funding of elections, and many have repudiated private funding. Given the complex nature and risk of partisan influence associated with accepting money from private organizations, again, this is for the purpose of election administration, I recently penned a letter to Wyoming's 23 county clerks. Together, we should be ever vigilant and aware of these tactics and try and prevent these efforts from coming into Wyoming. My hope is that Wyoming can join the 25 other states that have passed bans on private funding of election administration. And again, to talk about why this is important, it's important for us to get ahead of this. And in terms of the question of whether we've seen cases of this, not necessarily specific to Wyoming, but this is happening nationwide. One of the individuals who is alleged to have been involved in this effort is a resident of Wyoming. And he's a foreign national, not a voter, but is a foreign national who's a resident of Wyoming. It's not specific just to that, but there is a potential Wyoming nexus there, and I think it's important for us to get ahead of this.
Questions for the secretary? Representative Yoon.
Thank you, Mr. Chairman. Secretary Gray, so we have folks who do take private organization donations right now who administer elections. It's our county clerks and our Secretary of State. Should we ban those candidates for office from taking private organization donations? Because they also administer elections and there is influence when donations are given during campaign season.
Mr. Secretary?
Well, Mr. Chairman, the question of donations for the purposes of campaigning is a separate question, different from this bill. If you want to engage in a colloquy on that, I suppose we could, but I would prefer to keep it to the bill. And I think that's probably what we're doing. And for purposes of election administration, which is what this involved, my answer to that is no, that is totally inappropriate. And banning that is what this bill does.
Representative Yin.
Mr. Chairman, thank you, Secretary Gray. So you're saying that you are free from influence when organizations give you campaign donations from influencing you as an election administrator?
Mr. Secretary.
Mr. Chairman, this is for purposes of election administration. So we're talking about election administration here.
Representative Yin.
Pass.
Thank you.
Okay, Senator Barlow.
Thank you, Mr. Chairman. So as we think about elections, I think we think about public offices, but we have a lot of special districts and other things that are also have elections, et cetera. So I want to be clear, do all funds from all these improvement districts and all these other things, are they considered public funds, or are they actually considered something other than public funds? Maybe not private in the way this is being. So, but I just want to make sure that we're not telling a special district or somebody that, hey, you can't, and you're starting up a special district, how do you actually conduct an election if you don't get money from somewhere? So I think we got to, this is a management audit committee type of issue. Secretary Gray, you served on that committee.
Yes.
And we took up those issues. So I just want to be clear that we're not boxing something out that is current practice. i.e., how do you start a improvement district without private funds? Because that is a developer saying we're going to do this, et cetera? Are you going to have the county commissioners fund that election? Or, I mean, I just want to be clear that there's not a nuance in this we're missing, because this is all elections. I believe this would apply to. So thank you, Mr. Chairman.
Secretary of State Gray.
Mr. Chairman, I think I'm going to turn this over to council in a minute. A couple things I want to say, though, to introduce it. One, we're talking about election administration here. So I don't think starting up an improvement district, the funds, the capital to start an improvement district is involved here. Now, I think you could have an arguable case, in terms of conducting that special district election, which are often done at people's homes. But I mean, what would be the cost there? Now, I would want to dig a little bit into the definition to see whether that even applies to a special district. I will do that as we go out to public comment. But I don't see, even if it did, I think I would doubt that would really play out. Most of these special district elections are being played out at either at a person's house or through the county clerks. That is an area actually we are talking about looking at in the future for potential statutory changes. We have not gone down that road yet. In terms of the administration of special district elections, have a lot of just appreciation for citizens of Wyoming that do that work for special districts. And we don't want to do anything that is going to key them into anything that where they shouldn't be. But in terms of your question on its nose, I'm not sure the definition would apply to that. And I don't think practically how you'd really have application on that for a special district election. Now, I'd argue, look, if you have private funds going to like a massive electioneering effort involved with funding drop boxes or the administration of a special district election, I also think there's questions as to whether that's something that should be done. But I want to check first whether that applies to special districts or not. And I think in the narrow instance of election administration, I would argue, I think that a private funding of a special district election itself, not the capital involved in an improvement district, but the election itself I'd argue that would be problematic as well, and maybe a separate issue, but also something we'd want to look at. Do you want to say anything on that?
Representative Newsom.
Thank you, Mr. Chairman. Diving a little deeper into Senator Barlow's question, in our county, we had the conservation district is not funded. They do not have a mill, and they wanted to get a mill, and they proposed running it on a special election. It was determined that that would be of significant cost to run a special election. And there was discussion about could the conservation district go out and solicit private funds to help pay for that special election. And through this, that would be prohibited. They determined that they couldn't raise the money. And it was on the general election ballot. But I think that that's an interesting question about these small districts who, if they would want to have a special election, could private donors such as myself, who would like to have the conservation district funded through a mill, be able to contribute in order to get that special election to happen.
Secretary of State.
Well, and Mr. Chairman, again, I think this is an interesting nuance that I want to dig a little deeper into the definition here to get you an answer here, and we'll do that during public comments. So I'd appreciate a second bite to respond to that. I would, in that scenario, maybe push back about whether that applies to the first sentence, but I'd have to think a little more on that. I mean, we're really talking about the election administration. That's what we're talking about. But, an argument could be made the way that first sentence is written. But let's first talk about the definition, and let me do a little research on that, the way the definition's written.
Go Chairman Case.
I want to zoom back up a little bit to the higher level. So when you preface by talking about that Time Magazine article, and you mentioned a lot of the things that correspondent talked about, those sounded to me like lobbying activities, some of them. And so, there's running elections, and then there's lobbying, and lobbying's legal. It has rules, and there are things like that. running an election is, I think what this bill is trying to do, actually running an election. So it'd be the cost of the election and not lobbying, not a cabal of influencers or whatever. It's actual paying for election costs. And that's kind of what I'm comfortable with. But if this is just paying for election costs, it directly hits this issue with the special districts that sometimes have to solicit funds to get the initial election going. So do we make an exception for that, or,
Well, Mr. Chairman,
thank you.
I think part of what Ms. Ball is talking about, I agree that it might be a little bit on the rules around it, but then you have this whole issue of the funds that were used to funnel into the election administration, which ended up funding. We're supposed to fund masks and PPE and whatever and sanitizer, but ended up funding massive ballot harvesting efforts and Dropbox campaigns and things like that. That's what we're trying to get at here conceptually. And that I think is also predicated in the Molly Ball quote. I agree there are some clauses where she's talking about something different, but then there are clauses where she's talking about specifically what we're trying to get at in this bill, and that's why we cite it. But there are multiple things she was discussing in the article, but one of them is this effort to influence election administration, and that's what we're trying to get at in the bill. But I agree with you. We want to examine the implications on our special districts, and we're doing that now. But I'd also argue that I don't think funding a special district Dropbox campaign through private donations is, I wouldn't be thrilled about that. Now we're looking at the higher level stuff here is the number one priority, but I think arguably there are special district issues we'd like to solve here. Now, funding the actual the actual cost of conducting the election with the clerks as a pass through, that's maybe a nuance that we need to contemplate.
So, Mr. Chairman, thank you. May I follow up?
Go ahead, Senator Case.
I think we're kind of on the same page. I really do. So we want to get at these actual expenditures to conduct elections. We don't want to worry about influence and lobbying and all this stuff. And so if that's what this bill talks about, it says prohibiting government officials and election officials from soliciting, taking, or otherwise accepting private funds to conduct elections as specified. So if a proposed EMT district in a county, there's a pool of funds put in to conduct that election, that would probably be illegal. Even if it was administered by the clerk, it would be illegal under this bill. Is that a good thing or a bad thing? Well, that means that if there's a proposed district, someone else has got to put up the money, a branch of government, which means the county more or less would have to front the money for that, or it'd come out of the clerk's budget. I'm sure they're laughing, but I know they've got lots of money. Anyway, I think we're actually on the same page. I don't want private funds in these elections either, but this nuance of special election or special districts is possibly problematic. And maybe we should hear from the clerks as to how they conduct these elections. And sometimes they don't. Sometimes someone else does. Does this cover if someone else runs the election? So I hope we hear more about that.
Mr. Rubino.
Thank you, Mr. Chairman. If I could add on really quick, just to point to that. And again, I'm happy to look into this more as well. What I think that the wrinkle that might be being overlooked here or might be being missed at first blush is that what you have, I think, a little bit more attenuated than what might be being strung together here, right? So you have the bill, which prohibits election officials, county clerks, and the Secretary of State.
Mm-hmm.
But then you have special districts, which may collect private funds, or they may have a mill or things like that. They are interacting with elections officials to run their elections or whatnot. That doesn't make them elections officials. And so if you track that out, really anything could be considered private funding by that definition, because you'd have taxpayer funds. Well, what do taxpayer funds come from? They come from severance taxes, which are private organizations. Those are taxes. Then those, conduct regular elections, your general primary elections by county clerks and Secretary of State. That's not what we're getting at here. And I think I don't want it to become an attenuated thing where you're tracking a dollar to an election official administering elections. So I think keeping that in mind, that separation there, just because a special district collects funds and then they use those funds to help bear the brunt, it's the special district. It isn't a private organization. So it's not just like a pass-through entity or anything like that. They're separate things. Does that make sense? It would be different if you had a third party actually subsidizing an election directly. That would be to the election official themselves, the Secretary of State or the county clerk or whatever.
But the bill says government official or election official.
Well, and that might be something that I just want to make sure that we're talking about the same thing, that we're fleshing that out a little bit more.
Senator Scott.
When we get to working the bill, I'm going to propose an amendment that would give the Secretary of State discretion by rule to exempt certain classes of special district elections from the all or part of the provisions of this subparagraph A. And I mentioned that now, so people who are going to testify can think, but I think that may be a way to solve this problem. Because we're really, I think after our main general and primary elections here, and special district elections can be, Mr. Chairman, very different animals. I think we just give the Secretary of State some discretion to write some rules on that as to the extent that it proves necessary. That ought to take care of it.
Secretary Gracie, you're nodding your head. You have a positive opinion of that amendment then? Okay. All right. Thank you, Mr. Rubino and Secretary Gray. Clerks, if you want to testify on this, come on up.
Where's his entourage?
It's just you now.
Oh, Mr. Chairman, we have very little. Malcolm Urban, Platte County Clerk and President of the County Clerks Association. We understand the intent of the bill is to essentially codify what we do currently, which is that the county bears the cost of the election administration itself. The two things that we want to make sure of are clarified. Number one, the donation of polling places or advertising. We just want to make sure that's not prohibited. We've had a number of polling places, my county specifically, that normally charge a rental fee, but are willing to waive that fee so that we can have the polling place. They feel it's their civic duty to waive that fee. And so we just want to make sure that that maintains. That local newspaper and radio station in my county prior to the implementation of voter ID offered to do a PSA campaign free of charge that would just remind people occasionally that they needed to bring ID to the polling place. And so just make sure, if we're going to codify what we currently do, ensure we still have that leverage or that ability to have those donations for polling places and PSA campaigns. But number two would be that we still have the ability to bill special districts and municipalities for their proportionate share. Just as a side note, we don't bill the state of Wyoming, even though we have their questions on the ballot, but we just want to make sure we maintain that ability to bill the special districts and municipalities for their proportionate share, Mr. Chairman. That's all we have.
Senator Barlow.
Thank you, Mr. Chairman. And actually, that's exactly to the point. County clerks are getting reimbursed from these special districts. And my question actually was, are those funds considered public funds or private funds when they're coming from a special district? That's the nexus of where that comes in, because this specifically prohibits private funds regardless of source. So I think that is something that was the question I was trying to get to, is what are the funds that they are receiving? They are rightfully receiving funds for conducting elections on behalf of these districts. So thank you, Mr. Chairman.
And
Clerk Irvin?
And Mr. Chairman, we don't believe that's the intent of the bill, certainly. We just want to make sure that's abundantly clear that we still maintain that ability.
All right, thank you.
Thank you.
We have some public comment online. Welcome, Mr. Sneed. Go ahead and introduce, if you can hear us, introduce yourself for the record and then tell us what you'd like us to know.
Thank you very much, Mr. Chairman. My name is Jason Sneed. I am the Executive Director of the Honest Elections Project. HEP is a national organization which is dedicated to defending the right of every American to vote in free and honest elections and to preserving public confidence in the democratic process. I'm not here to take a particular position on a bill, but we have closely studied the negative impacts of private election financing across the country, and I wanted to share with the committee what we have learned. Ensuring that election administration is conducted in a neutral and nonpartisan fashion is crucial to public trust in the election process. Private election financing puts that trust at risk, particularly when those funds are traced to ideologically motivated organizations or to individuals who have donated to or have a personal or financial stake in the outcomes of elections. The perception that election administration itself is or can be politicized in favor of one party over another is entirely corrosive to public confidence. That's why 25 states have passed laws in just the last 2 years to ban or restrict the flow of private money into public elections. Several of those states passed those laws on a bipartisan basis, which I think is highly commendable, particularly in our polarized political era. Unfortunately, private funding programs remain an urgent and pressing issue, and we have strongly encouraged all states to ban or restrict private election funding. As Secretary of State Chuck Gray recently warned in a letter to Wyoming clerks, the Center for Tech and Civic Life, which was the organization that dispersed $350 million in private election grants in 2020, has created a new program, the U.S. Alliance for Election Excellence, which unites CTCL with other organizations that are funded by liberal donors and run by individuals with deep and long-standing professional ties to left-wing partisan politics. My organization has spent since the launch of that program tracking through FOIA and other means, and I have to say that I share Secretary Gray's concerns that were raised in that letter. The U.S. Alliance for Election Excellence is an $80 million program that targets local elections offices. In states that do not have a prohibition on private funding, grants in the millions of dollars are being dispersed, but the program is structured to allow it to evade private funding restrictions as well. The intent of the program is to gain direct access to election administration and to the officers that run these offices to gather data, and then to develop what the Alliance terms improvement plans that are intended to reshape the way those offices function. When offices join, they also gain access to Alliance coaching, training, legal advice, and even political advice. Worse yet, the Alliance creates a potential conduit for foreign influence directly into election administration. There is a foreign national, Hans-Jörg Wyss, who happens to be a resident of Wyoming. He is Swiss, and he has personally poured nearly $500 million into a variety of progressive causes. Since 2016, he has put at least $245 million into New Venture Fund, which is a grant-making entity managed by Arabella Advisors. In 2020, that organization, New Venture Fund, gave $25 million to the Center for Tech and Civic Life. And two of CTCL's major partners in the Alliance, the Center for Secure and Modern Elections and the Institute for Responsive Government, are both fiscally sponsored projects of the New Venture Fund. In other words, by creating a new private funding entity, CTCL has created the potential for foreign influence to impact election administration. We find that to be deeply alarming. If there is any doubt as to how corrupting the influence of private funding can be, consider that just recently, officials in Brunswick County, North Carolina, refused to withdraw from the U.S. Alliance for Election Excellence, even after county commissioners voted unanimously calling on them to do so, citing the alliance's blatant partisan leanings. In Georgia, CTCL and the Alliance actively evaded the state's private funding ban, working with DeKalb County officials to funnel $2 million into their elections office, despite a statewide prohibition. And in Missouri, Boone County joined without initially informing the public. Put simply, private election funding puts public confidence in elections in jeopardy. The issue is not about which side is doing the funding. Private funding itself is the issue, and it is inherently corrosive. It creates perceptions that the democratic process can be skewed for political gain. Fully funding elections with public funds remains the widely recognized best practice, which protects the integrity of elections, protects clerks and elections officials against undue influence of special interests, and ensures public trust in our voting system. With that, I'll close my comments. I appreciate the committee's time and the opportunity to testify, and I'm happy to take any questions if there are any.
Questions for Mr. Sneed? All right, thank you, Mr. Sneed. Is there anyone else online? Okay, back to the room, public comment. Welcome back.
Gail Simmons, Civics 307. I put another page together that is a comparison of the case against private funds in public elections to the case against public funds in private elections. And it covers the full range of that. The point that I would like to make is that the need, the opportunity or the likelihood of accepting those funds really came out in that 2020 election because of underfunding that was identified or at least claimed for public elections. That does not happen in Wyoming. So again, I like to have us come back to what occurs or could occur in Wyoming. Our legislature, thank you very much, and our county commissioners fully and adequately fund our elections. There's a reason why Wyoming received none of those funds for 2020. It wasn't needed, but more importantly, for them to come in and to be used by the county clerks, they would have to be registered as a revenue. In other words, brought in and into the system as a revenue. And when the money was expended, it would be in the system as an expenditure. So the visibility is there, at least in this state. Does anybody in this state want private funds in public elections? No. And I certainly do not either. First of all, because it's unnecessary. Secondly, because of all the reasons that are listed against it. My question is this such an urgent matter that this needs to be in and of itself as a part of a larger view of Title 22 and some of the others? Is this something that needs to be addressed in a short session of the legislature, given that we've already funded I believe has already been funded for 2024. And we already have things in place that would prevent this. So while I agree that it should probably be put into statute, I don't think the urgency is there for you to pass this right now. I would also say that this is actually a part of a larger review that needs to be done on both sides of that line of Title 22 that would be in a future interim look that would include all of the parts, including major versus minor parties. And I know that our majority party has an issue with that, including campaign finance, election integrity, all these little piecemeal things. I made the correlation last night to Johnny Cash's Cadillac, the one where he took apart every year for several years. And so he had a 62, 63, 64, 65 Cadillac. we're doing that with Title 22. And we've done that for quite some time. So I would say there is no urgency for the 2024 election to put this through now. And I would say consider this along with the whole public funds in private elections as a part of 2022. And I would also say that while it was specifically stated this is about election administration, frankly, anything that interferes or has outside influence, including non-US influence, is of concern, which means that if when you specifically state against Zuckbucks, if I can use that, and you are not opposed to super PACs that came out of Citizens United, I would say you need to check your consistency, because the problem is worse for dark money than it is for those that we can actually see in them. So I'm for this, and this is not the time. And I stand for questions.
All right, thanks, Gail. Any additional public comment? Yes, ma'am, come on up.
Hi, I'm Gigi Lehman from Commerce County. And in response to a lady that was just before me, I would say there is no time like the present, because if you're going to do something, do it now when time is of the essence, to make sure that we are going to ensure that we have safe and secure elections and we do them properly. I think that's what you're all elected to do, and quit kicking the can down the road for something later. That's all I'd say.
Committee? All right, thank you, ma'am.
Thank you.
Any additional public comment?
Thank you, Mr. Chairman. Don Odom, State Director for Restore Liberty. If God forbid any of us had a home burned down while we're here today, it'd be too late to call the insurance agent to get home insurance or rental insurance if you were renting. So like I mentioned earlier, just because it's not happened yet is not a reason to go ahead and have a preventative measure in place. That's all I had to say. Thank you.
All right, thank you, Mr. Odom. Any additional public comment? No, I will close public comment. Senator? Well, let's move the bill first. Okay.
I move we introduce this bill as a committee bill at the budget session.
Okay, it's been moved and seconded by
Mr.
Representative Harshman. Yes.
I have two amendments.
Okay, let's hear them.
Mr. Chairman, first one would be on page 2, line 10, after staff period, insert. The Secretary of State may by rule exempt any particular class of special district elections from all or part of the provisions of this subsection.
I'll second.
It's been seconded by Senator Landon.
Mr. Chairman,
Yes.
what this is intended to do, I don't think there will be any problems in response to the county clerks about ability to bill municipalities for the cost of elections, that's public funds, or special districts for the cost of their elections, that's their funds are public funds. I do think there's likely to be some issues with regard to the formation of special districts. And I think that just giving the Secretary of State some authority to deal with those is the best way to deal with this. So that's what I'm trying to do.
Okay. Think everyone's on the same page, understanding it. Question on the amendment. All those in favor signify by saying aye.
Aye.
Any opposed? Okay, that amendment carries. You have a second amendment?
Mr. Chairman, yes. on page 2, lines 16 through 19. What I want to do, and I'll give you the specifics, Mr. Chairman, is make this a minor misdemeanor. I'll explain if I get a second. Page 2, line 17.
Is there a second?
Delete felony.
Is there a second?
Let me make it first.
Oh, I thought,
Okay.
I understood your amendment to turn it to a misdemeanor.
Well, that's what I'm going to do, but I'm going to give you the specifics.
Okay, go ahead.
Page 2, line 17, delete felony, insert misdemeanor. Line 18, delete 5 years, insert 6 months. On line 19, delete $10,000, insert $750.
Before I second clarifying question. This applies just to election officials, right, Mr.
Yes,
Chairman?
that's right. That's why
Yeah.
I'm doing it that.
Okay, I'll second.
Okay, it's been seconded by Senator Case.
Mr. Chairman,
Yes.
frankly, I think if we make it illegal for a public official to accept, doesn't matter the penalty, no public official in Wyoming is likely to do it. So I think the thing to do is keep the penalty low so nobody gets excited about it. I don't think a new misdemeanor penalty will cause trouble, but a felony provision will cause, at least in the Senate, I think, discussion and trouble on the floor. We're getting nervous, too many felonies, Mr. Chairman, and we should be. So that's the purpose of this. And it might be different if it applied to more than public officials, but this is the way it's written and properly written, applies to public officials.
Okay, Senator Barlow.
Thank you, Mr. Chairman. So I would oppose this if I'd gotten to a motion before the senator offered his, because I was going to actually offer as well, because currently this is about soliciting, taking, or accepting. Well, what about the individual that offers it? In that case, I would have been quite comfortable with the felony. I understand the other perspective. So with the context of what this bill accomplishes as written, I will be supportive of this amendment, understanding that I still may bring something that says, if you offer these funds, we had several examples. I do think that should have a higher burden. So anyway, thank you, Mr. Chairman.
All right. Representative Yin.
Oh, sorry.
Mr. Chairman, thank you. I would just offer that by default in Title 22, the default penalty, if there isn't a specific penalty, is a misdemeanor of 6 months or $1,000 at the most. So if we struck it, it would just be 1,000 instead of 750, but it would be this, it would actually be it'd be slightly different. So I'm fine with this amendment, but I think we can make it even a little cleaner by just striking the subsection C altogether.
What do you think, Senator Scott?
Mr. Chairman, I think we just struck the whole subsection. Maybe that'd be the better way to go.
Yeah.
I wasn't sure that was the case.
Okay.
So you want to withdraw?
Yeah, I'll withdraw that.
I'll withdraw the second.
And your new amendment is to strike subsection C.
See, yeah, and LSO staff fixed the title accordingly.
Okay.
Question.
All those in favor signify by saying aye.
Aye.
Any opposed? All right, that amendment does pass. Any other amendments?
Question on the bill.
All right, and this will be a roll call vote. LSO.
Mr. Chairman, this is a roll call vote for 24 LSO 0092 version 4, prohibition on private funds for conducting elections as amended. Senator Barlow. Senator Boner.
Aye.
Senator Landon.
Aye.
Senator Scott.
Aye.
Representative Chadwick. Representative Haroldson.
Aye.
Representative Harshman. Representative Knapp.
Aye.
Representative Newsom. Representative Ottman. Representative Wiley.
Aye.
Representative Yin. Senator Case, co-chairman.
Aye.
Chairman Olson,
Aye.
14 aye.
All right.
Close.
Now, committee, do you want to go to lunch or do you want to try to get through one or two more in 30 minutes? Lunch in a half hour? Oh, sure. We'll come back a half hour earlier. You want to, what do you think, committee? You're making good pace. Let's keep rolling. Let's go to 24 LSO 0093 political expenditures. Is this one you, Mr. Plum? All right.
Mr. Chairman, discussing 24 LSO 0093. This is a joint resolution on political expenditures. And so beginning on page 1, as I mentioned, it's a joint resolution. There are 5 whereas clauses, kind of explaining some of the thoughts there. So just to briefly run through that, the first whereas on page 1, line 5, just specifically says that the U.S. Supreme Court has ruled that Congress and the states cannot limit independent corporate expenditures to political campaigns, and essentially means that they're relying on the concept that the spending of money to elect a candidate is protected speech. The second whereas paragraph on line 11 on page 1 says that the U.S. Supreme Court ruling has allowed for the creation of super PACs that make unprecedented campaign expenditures, and that those expenditures cannot easily be traced back to a natural person. On to page 2, the first full whereas clause there on line 5 just says that Wyoming legislature has grave concerns regarding a corporation's ability to make those expenditures, and that those expenditures may financially overwhelm individual persons in the political process. On line 12 of page 2 says that the U.S. Congress, state legislators, and local legislative bodies should have the ability to require identification of campaign expenditures and to have the ability to limit those expenditures from non-natural persons. And the final whereas clause is just that a constitutional amendment would control over the U.S. Supreme Court's ruling in interpreting the United States Constitution. So then kind of at the top of page 3, section 1 is the request of the resolution that the legislature of the state of Wyoming respectfully urges the Congress of the United States to propose and send to the states a constitutional amendment to do 2 things: to allow for the public identification of the source of political contributions or expenditures, and to limit or prohibit corporations and other entities that are not natural persons from making campaign contributions for or against any candidate. It does specify that political expenditures by organizations that are comprised of natural persons that publicly identify themselves should not be restricted. And then section 2 is just that the Secretary of State should transmit copies of the resolution to the President of the United States, President of the Senate, and Speaker of the House of Representatives, and to the Wyoming congressional delegation. With that, I'd stand for any questions.
Questions about the construction of the bill? Yes, Senator Scott. Your microphone.
Mr. Chairman, this looks to me like the one this committee sponsored last year. Is it word for word identical?
It wasn't, it was a private, I think it was an individual bill.
Isn't it an individual bill?
No, was it a committee bill?
Mr. Chairman, I thought, it was a committee bill. Yes.
Oh, on the Senate. Well, then this bill was on the Senate side, died on the Senate side, and then was brought as an individual bill on the House side. Got it. Okay.
That's correct. That is correct.
And Mr. Chairman,
Yes.
a lot of the language in section 1 came from Senator Scott, and it's in here now. I think there is down the road, we're looking at an amendment proposed by the good representative sitting out here that probably is a necessary amendment, and we have passed this before.
But Mr. Chairman and Senator Scott, yes, it is the same.
Okay. Thank you, Mr. Plum.
Before we go to our usual election cast characters, could we hear from Representative
Chestik?
With his proposed amendment? He's been behind this bill for a long
Sure.
time.
Come on up.
I think it'll speed things up.
Thank you, Mr. Chairman, and that is correct. This was a committee bill, so
Go ahead
many of you.
go ahead and introduce yourself for the record.
I am Representative Ken Chestik from House District 13. And this was, I'm also have been working on this for some time with a group called Wyoming Promise, but this right now, this was the bill that was adopted by this committee as a committee bill in the last interim. This is word for word the original language that was presented to the Senate. The Senate passed it onto the floor, and it died on third reading for reasons. It was on the consent list. There was no debate on it, so I don't know why it was defeated. I did try and bring it as an individual bill, but we didn't get to it at the committee. We ran out of time. So this is a transparency bill. It's an opportunity or an effort to increase transparency in campaign donations. Corporations, according to the U.S. Supreme Court, have the right to political speech. And that's something that I find problematic because corporations have different interests than human beings do. There are 23 states that have already adopted similar resolutions that have called on Congress to propose a constitutional amendment. The reason we're asking for a constitutional amendment is that is the only way to get past the Supreme Court precedent that says money is speech and corporations are people for the purpose of political speech. As was mentioned before, this language has been worked over by this committee in the last interim. This is language that was approved and worked on by Senator Scott, did some great work on coming up with this language. The one thing when I've been trying to find out what went wrong in the Senate, why it failed on third reading in the Senate, the only hint I got was that there was some concern that this bill was targeting corporations, but not unions, and that unions would have more rights than corporations, which is not the intention of the bill, never was the intention of the bill. The intention is that non-human entities should not have political speech. Only human beings should have the right to political speech. So I've circulated to the committee a proposed amendment that would clarify that point. And that is on line 6, page 2, line 6, after the word corporations, to add the words unions and other non-human entities. And then also on page 2, line 8, just replace the word corporations with such entities. So it now very explicitly says that unions, corporations, other non-human entities that, according to the rest of the language, that aren't identifiable by individual persons, would all be prohibited from making political speech. Again, the idea is to increase transparency so we know who is making donations. Ordinary PACs who do have to identify their donors would still be able to make their donations and make their contributions, but super PACs that can hide their donors would not be allowed to make unlimited contributions the way they are right now. So that's my offered amendment, and I'm happy to stand for any questions.
Questions for the representative? Senator Scott.
Mr. Chairman, comply with the drafting standards. Can we say these entities instead of such entities?
That's fine by me.
Mr. Chairman.
Senator Case.
More to the structure, I think the non-human entity kind of it's strange to me. We don't typically use that. Can we say something like corporations, unions, and other individual or other entities besides individuals? And I'm thinking nonprofits, there are many things besides corporations out there. And I'm really trying to say other entities besides individuals.
Yeah, could you just say organizations?
Yeah.
Corporations, organizations.
Yeah.
Organizations would cover all nonprofits, LLCs.
Yep. And Mr. Chairman, I'd like to get away from the non-human entity thing. That's just too weird for me in legislation. Other than individuals, if that works for people, but I don't know. Individual persons is fine. Other than individual persons.
All right, sounds like the author's pretty workable on it. So when we get to the bill, we can work in some language, I think everyone can agree on. Any questions for the representative? Other questions, I should say. No? All right, thank you.
Thank you.
Secretary of State's office, do you have any public comment? No. Clerks, do you have any public comment? No. All right, general public comment. Do we have anyone signed up who's raised their hand online? No one online? Okay, back to the room. Anyone in the room who would like to make public comment on this bill? I will close public comment. Committee, what is the pleasure?
You pass.
Mr. Chairman,
Okay, it's moved to pass by Senator Case, seconded by Senator Landon. And then let's go through, let's get these amendments.
Mr. Chairman,
Senator Scott.
can I ask Senator Case to make the motion on this? Because I didn't quite understand what he was doing with the non-human.
I think he's penning it in right now.
Let me think out loud, just to take the work off the sheet that he was given in page 2, line 6. After corporations, add unions. Organizations. And organizations other than individual persons. Natural person. How's that? Corporations, unions, and other organizations.
Other than national.
I mean, doesn't that cover it?
Yeah, I think it does.
I think if you just say corporations, comma, unions, comma, and organizations, you've covered it.
I'm good with that. Let's do that. That's exactly my motion.
All right. Okay. And does your motion includes the rest of
Page 2 lines, yeah.
page 2, line 8 as well?
Mr. Chairman,
And I know Senator Scott had an amendment to this.
well, I just wanted to replace this such with these.
Friendly.
Okay. These entities instead of such entities. Everyone understand the motion? Senator Boner?
Clarification on page 3, it looks like there's similar language, page 3, line 7. Kind of this weird, calling out corporations, but nothing else. I'm wondering if that's part of the motion to fix that as well.
Give the reference again.
Page 3, line 7. And it would be line 8 for the.
Yeah.
Oh, wait, I'm looking at page 2, sorry.
Well, page 7 says prohibit corporations and other entities that are not natural persons. So it stands by itself.
I think it's all right.
This says prohibit corporations and other entities that are not natural persons, so we're probably okay. Yeah. Okay, any other discussion on the amendment?
Question on the amendment.
Question on the amendment, all those in favor signify by saying aye.
Aye.
Any opposed? That amendment has passed. Any other amendments?
Question on the bill.
Question on the bill, this will be a roll call vote.
Mr. Chairman, for roll call 24 LSO 0093 version 5, political expenditures as amended, Senator Barlow. Senator Boner,
No.
Senator Landon.
Aye.
Senator Scott,
Aye.
Representative Chadwick,
Aye.
Representative Harrelson,
No.
Representative Harshman,
Aye.
Representative Knapp.
No.
Representative Newsom.
Aye.
Representative Ottman. Representative Wiley.
Aye.
Representative Yin.
Aye.
Co-chairman Case,
Aye.
Co-chairman Olson,
No.
nine aye, 5 no.
No, we don't have, it's the majority of the totality. Yeah. So it does pass.
All right. Let's see
Want to do one more?
if we can get through one more. 24 LSO 0094 candidates for state legislature residency requirement. Mr. Plum, is this you as well? All right.
Thank you, Mr. Chairman. This is 24 LSO 0094 candidates for state legislature residency requirement. Does just amend the statutory provision for eligibility to be a candidate for the state legislature. And so what it essentially does is, based on the constitutional requirement, right, that a candidate for the state legislature from a district has to be a resident of that legislative district for at least 1 year. And it used to say next preceding his election, but now it's been changed to say for at least 1 year before the date of the applicable general election. So the one that he'll be coming up to. And then there's the conforming amendment in paragraph 2 that it, once again, would be a resident of a county for at least 1 year before the date of the applicable general election in which any portion of the district is located. And so I just did want to briefly mention on the bottom of page 2, I have the staff comment, and just for the committee's consideration, the one other place this really kind of comes up for candidates is with municipal officers in Wyoming statute 22-23-103B. And that they have to be a resident of the ward in which they're seeking to be on the council for 1 year. And but based on the request, did not make that change, but it could be similar to that if the committee wished to pursue that question. So the effective date is July 1st, 2024. I think with that, I would stand for any questions.
Questions for Mr. Plum? Representative Harshman.
Mr. Chairman, and maybe just for the entire committee too, and I know maybe explain for everybody, is there an issue then with adding the word primary or general? Because, a lot of our elections, of course, don't have a primary, but the ones that do are very important. But can you explain the issue behind that, or is there one? Thank you, Mr. Chairman.
Mr. Plum.
Mr. Chairman and Representative Harshman, thank you. I actually did mean to address that. And sorry, I just skipped it in my initial explanation of the bill. The Wyoming Constitution in Article 3, Section 2, it provides for member terms and qualifications. And so, senators shall be elected for 4 years, representatives for 2 years. And at the end of that paragraph, it says, you are only eligible to be a legislator if you have at least 12 months next preceding his election resided within the county or district in which he was elected. And so if we make it general, I think it's fairly straightforward that if you're elected, at the general election, you would be a state legislator at that point as having received the positive vote. I think there might be difficulty in, you might see some issues, some pushback if you try to set it back to the primary, because of course you can win your primary, but lose at the general election. So it's just that reading of the language, that you have to reside within the county or district in which he was elected. And so I think that's kind of the reason that the general was put into this one. But then that was the reason why primary may present a challenge.
Very good. Any other questions for Mr. Plum? Representative Ottman.
Thank you, Mr. Chairman. Mr. Plum, does this in any way affect people from out of state running in our elections at all? Like I know there's people that may run and then they say on the date of election, I was here, but to keep people from running actually for an office?
Mr. Plum.
Mr. Chairman, Representative Ottman. Yeah, certainly. I think, based on the constitutional requirement and then how it reads in statute, I mean, very specifically says that you have been a resident of that legislative district for at least 1 year. So I think it really would prevent any person who, if you don't reside in your specific legislative district for that prior year, I don't think you would be able to. I think that could be very well good grounds for a challenge to that person trying to run. Or did I misunderstand your question?
Representative Ottman.
Thank you, Mr. Chairman. No, that's what I'm trying to address, but some people, and I'm not sure exactly if this is the place in statute. I guess that's why I'm asking. Some people actually from another state put their name on the ballot and wait to see how that's going to go, whether or not they're elected. And if they're elected, they would move into the state. Does this affect that?
Representative Ottman, I think you're thinking about the federal elections.
Maybe.
This is only applicable to state legislatures.
So in state, you cannot do that.
Mr. Chairman, Representative Ottman, yes, I think, I am seeing this. This is specifically for candidates for the state legislature of Wyoming only.
Okay.
Yes, it is that. Yeah, absolutely.
All right, thank you, Mr. Plum. Oh, no, one more, Representative Harshman.
So, Mr. Chairman, and really for the members to kind of think about it, I know that our Constitution has those. And it's all about with a pushback on it, but really you think about, so a person, right, even if we pass this bill, to not be a resident of Wyoming and file to run. And then be elected. Cause you know, if they're here. So there's that window between filing and the actual general election. So you can file to run and not be a citizen of Wyoming. I mean, that's what it is. That's the Constitution says a year for the election. But to think about that a little bit. Okay, thank you, Mr. Chairman.
Senator Scott.
Mr. Chairman, I don't think so. I think this, because you have to file sooner than that. You have to be a resident when you file, because otherwise you won't have been a resident for a year when you're elected. So I don't, with this provision, which I think is strictly implementing the provision of the Constitution. I don't think you're allowed to file and then see if you're going to be a resident, because you won't make the year requirement.
Mr. Chairman. Well, you'd be a resident, but you wouldn't be the resident for a year. That what the bill makes sure is that you are a resident for a year when the general election occurs. Yeah. Yeah. So, and I think that's consistent with the Constitution. You remember, we had a little discussion about residency earlier today, and you don't have to be here a year to be a resident of Wyoming. So, that residency isn't determined by the year. Being a candidate and on the general election is determined by the year.
Representative Harshman.
Thank you, Mr. Chairman. And being a candidate on the general election, correct, but not to file for office.
Correct.
You can be here 8-9 months and file for office.
Well,
actually, yeah.
You got to do the math, but
Yeah, I mean, you can be here less than a year and file for office.
yes.
Just so everybody kind of let that sink in a little bit.
Senator Landon.
You know, just to add to that, so that committee has this to ponder as well. The way this reads probably isn't as strict as I would like it to be. I have a lot of constituents who come up to me all the time who say, you know, I don't mind people moving here, but I don't want them to change Wyoming. So the deal is the way this reads right here, you can conduct an entire campaign before you're elected and still not have been a resident for a year.
Correct.
You can go all the way up to November 5th. And literally have that be your anniversary date of being here a year and get elected the next day, for example. So that's the way it reads. It's a policy decision for all of us in the legislature to consider whether or not we want somebody to be a resident when they're running for office, running to go to Cheyenne. So,
Mr. Chairman.
Mr. Chairman.
Senator Case.
Mr. Chairman, you have to think about the constitutionality of it. So if we were to say, you have to be a resident of Wyoming for 10 years before you run for the legislature. Constitution says 1 year. Court's going to say Constitution rules in this instance, you're trying to restrict office. So we're splitting hairs by the year or 8 months or whatever, but it really is cleaner to say a year at the general election.
Mr. Chairman.
Senator Scott and then Senator Bonner.
Mr. Chairman, and there is court precedent that you can't add requirements for running for office to the constitutional one because of the term limits decisions.
Senator Bonner.
And just along those for lines, just so I understand that reading the Constitution, it says at least 12 months, which in my mind would give us the ability to make it longer if we wanted to, but it sounds like there's some court precedent that prohibit that. I'd hope to better understand that as we discuss that.
Well, Mr.
Senate
Chairman, if it
case.
said at least 12 months as determined by the legislature, I'd agree with you, but it's just stands there and says you've been here a year.
Senator Scott and Senator Landon.
Mr. Chairman, the, at least I think here is to prevent somebody from saying, oh, if you've been here 24 months, you can't run.
That's right. Senator Landon.
So, Mr. Chairman, just to sort of put a final thought out there regarding this entire issue. There was some conversation, and Mr. Plum, I'm not sure if you considered this, but my understanding is that there is precedent to not consider our primary election an election. So when there's reference to an election, it's only the general election. Is that correct? So we don't have the flexibility under the Constitution to consider the primary election to be the 1 year out. If that were the case, then you pretty much would be a resident prior to the primary election. But my understanding is that we could not adopt that language. Is that correct?
Mr. Plum.
Mr. Chairman, Senator Landon. Yes, I think based on, kind of how the constitutional provision reads, and then, based on, I think a lot of the statutory provisions not related specifically to the primary election do reference the general election. I think it makes the most sense to make it, set it at the general election.
Representative Yin.
Mr. Chairman, thank you. The one thing I would point out is that there are places in our Constitution which explicitly say general election, even though this clause about residency only says election. So do I think it's possible that it could be set to the primary election if we as the legislature consider that an election? I do. I think that's constitutionally allowed. But I do think that there is some ambiguity there in the Constitution because there are places where it explicitly says general elections. And the clause that we are referencing is not one of those places.
Representative Newsom.
Thank you, Mr. Chairman. I guess a clarification from Mr. Plum is what does next preceding his election mean? Is that a year? What does that term mean? I'm confused.
Mr. Plum.
Mr. Chairman, Representative Newsom. I think really it can be a reading, right? It would be at least 12 months next preceding his election and it's reside within the county in which he was elected. And so I think it does proceed more so to say, if the general election is November 6th, you have to have been a resident for a year before you are next elected. And so it'd just be 1 year and then it's the next preceding election.
So that essentially means the same thing. We're just rewording it.
A little bit, yes, Mr. Chairman and Representative Newsom. I do think it's 12 months next preceding your election. And so it's just saying specifically 1 year before the next time you're elected.
Okay.
Essentially next preceding election.
And
And you have to be within the county or district in which you were elected.
Mr. Chairman.
Representative Newsom.
Thank you. And so this new language, the before the date of the applicable general election, doesn't change anything with the residency requirement. We're just changing some words. Are we talking semantics? Are we talking an actual change in the residency requirement?
Mr. Plum.
Mr. Chairman, Representative Newsom. Yes, I think, the question was, is the next proceeding his, right? Like, I think there is a good question for that, but it just says election. This one is clarifying specifically that it's the date of the applicable general election. That was how I understood the bill draft request to be, was that it was just to specifically clarify 1 year before the next general election.
Senator Scott.
This bill, the constitutional provisions would still govern, and we aren't changing those.
Mr. Plum.
Mr. Chairman, Senator Scott, as I understood the committee's request, it was, to provide clarity to this statute, specifically when the 1 year would apply for candidacy.
All right. All right, thank you, Mr. Plum. Secretary of State's office, do you have comments on this bill? I don't think so. Clerks, do you have any testimony on this bill? Sounds like you do.
I'm trying to figure out what you.
Mr. Chairman, Julie Freeze, Fremont County Clerk, and one of the other more astute clerks brought this to my attention. I don't know if it matters or not, but it says for the purpose, kind of goes with what Representative Harshman says, for the purpose of meeting residency requirements of the Wyoming Constitution, a person shall not be a candidate. Candidate. Does that make any difference in what you're discussing? We just wondered if it did.
Mr. Chairman,
Now it makes it a candidate. So
I've been going over this because I heard from Ms. Freeze a couple minutes ago. But that's not the important part. You can't be a candidate unless he has been a resident of the legislature for 1 year before the date of the general.
okay.
And I
We didn't
think
know
if
if
you
the
read it, before the date of the general modifies,
That part of it. Okay.
yeah,
Just double check.
you threw me for a loop there.
Any public comment online? Mr. Who? So Sweeney.
Be good to see him.
So,
Welcome, Mr. Sweeney. The Honorable Mr.
thank
Sweeney.
you, Miss. Thanks. I don't know how honorable. So thank you, Mr. Chairman. I'll just be brief. So where the previous Secretary of State, I had after the primary, not in my race, but another race in Natrona County, I had constituents come up and ask me on the particular candidate, was it even possible? And so I called Secretary Buchanan's office. They did more research and then got back to me. And it was his opinion that it actually could be up to the swearing in according to the Constitution on the residency. So in that particular case, the general election, in my mind, does make it better. But I would argue that I believe that it would be very proper, given previous testimony on previous bills today, on the primary, make it more viable, in my opinion, that they've got to be, the candidate has got to be in residence in that particular district, Senate or House for a year prior to the primary. In basically the primary, as previously stated in our state, is the determining factor 99% of the time on moving forward. So why wouldn't we want to go to the primary? But there again, general is better, at least general election would be better than in January on the swearing in date. But keep in mind, Representative Harshman's comment about you could be in the state 9 months and run for office. And as long as you hit the requirement, win in the primary, you're not a year in as far as a resident. win in the primary and, you know, obviously win in the general election, that's their 1 year point. So I would ask consideration of the primary, but understand, and that's all I have on that. Thank you, Mr. Chairman, for the committee's time.
And thank you, Mr. Sweeney. Always a pleasure. All right, no questions? Okay. All right, Mr. Secretary.
Well, thank you. And, you know, in light of the last comments, I thought some of the discussion on the constitutional aspect, the committee had somewhat come to a conclusion that I think was the right direction. But, you know, on this primary versus general thing, first of all, you're certifying when you as candidates, remember this, and I was just looking at our system yesterday, we're talking our updates. We're actually going to update this system. We're going to make it so you can do it on your cell phone now, and it's easier. It's one of our updates. But when you do this, it's an attestation, or it's something you're signing as to the future that you're going to hit that, and it gets to the constitutional provision at the time of your election. And the time of your election is the general election. The primary is an election, but it is not the time of your election. The time of your election would be at the general and possibly arguably at the certification. I know the previous SOS argued possibly up to the time of swearing in. I don't think I would make that argument. That is not in rule, and we've not had that situation come up. But one thing I would caution you, and I'm going to turn this over to Mr. Rubino in a moment. I think in terms of the way this statute is structured, where you're modifying the Constitution, I think placing the primary has some problems with it. And there's other ways to do it, maybe. And I'm certainly all for durational residency. We talked about that for 2.5 hours here this morning. And you look at the law review articles on this, most of them talk about durational residency for voting, and then they add this nuance for holding office. And there's a whole case law on that as well. And it's an interesting one. But I would say that I do think there are some legal implications to adding primary in a statute where you're modifying or at least defining the Constitution, which in and of itself comes with some interesting questions. So I think it gets to some of what Senator Case was talking about earlier. Want to say anything?
Sure. Mr. Chairman, Joe Rubino, Policy Director for the Secretary of State's office. Just to add to that and flesh that out a little bit more, not everyone that makes it to a general election goes through a primary election. So you could potentially have an independent candidate, for example. You could have a minor party candidate, for example. You could even have a write-in. So then you're applying different standards for depending on how it's written, different standards if you say primary or general, but then you would have to specify which candidates that applies to. That raises equal protection issues. And then I think more to the point is it's going to be very hard to actually enumerate in the statute, A, without bifurcating it out from a constitutional standpoint, but B, if you don't bifurcate it out and you just say the primary, well, now there's an entire class of people that can make it to the general. I guess they didn't have to have a residency requirement to run. That would be, I think, the caution that I would impart on the committee with identifying primary at all.
Representative Harshman.
I guess my thought in talking about this would not be so much that it's really the date, right? Would apply to everybody. And maybe this committee should really look at a constitutional amendment to clarify really what we want potentially. But so wasn't talking really about classes, but we all see the hiccup in this thing is really the date, right? You can apply and run in the primary and not be a year-long resident, even with this bill. So thank you, Mr. Chair.
Representative Newsom.
Thank you, Mr. Chairman. I know, realizing that you haven't been through an election yet, but, and I don't recall when I've have filed in the past. Has my residency been verified that I mean, I've lived in the same house for 30 years and lived in my district for 40 years, but when somebody files and we put our address, then do you ask for verification that we have lived there for a year or lived in our district for a year? Does the Secretary of State's office do that? Have prior Secretary of States done that? And would you, as Secretary of State, take that step to ensure that every candidate has lived in their district for a year? Thank you.
Secretary Gray.
Well, Mr. Chairman, thank you. Absolutely. And this is a priority of mine. We were actually just talking about a little bit, some of the nuance, one around the new SF 120 and making sure that people assert that they have received this right to vote, the right to hold office again. That's a little bit of a different context, but then you have the second question of certification of your residency requirement, that you've met that. And first things first, it is an attestation, just like earlier. I don't have my tech director here. We talked about this. I believe then there's a cross check with YO-Reg. And one of the things we're working on with our elections director is I'd like to have a manual cross check. But as you remember, everybody's refreshing at 5 p.m. and people are submitting. So how does that work in the daily list? And talking with our tech director, I had asked that question and a couple months ago, and I believe the answer is there is an automatic check with YO-Reg that you've been in terms of the registration, but again, you're attesting that you have residency, which is a little bit of a different question from being registered. But then I would also like to institute some sort of manual check. But again, we're talking about residency here, which is different from being a registered voter. And that ultimately is an attestation. Representative Newsom.
A follow-up. Thank you, Mr. Chairman. So I guess, given that someone would be running for the legislature in a specific precinct, that there would be a requirement that they prove through utility bills, through however Wyoming Game and Fish does it, that they have lived in their district for the required amount of time, and that be more stringent than somebody registering to vote, because they're registering to hold elected office. And there is a requirement within our Constitution about that. And so I'm wondering that there would be a different standard, because I don't believe when I've registered to run for office that anyone has ever required that I send a utility bill or something that assures that I am have been a resident and that I live where I say I live.
Mr. Chairman, right now it is an attestation, and I'm happy to visit with you on how we explore how to address that. There is, and I've thought about it a lot too. I mean, there is always sort of the practicality that we got to certify this list. There's always the complaint procedure, and there were a couple last year, and that's what it gets rolled into. And then you have that procedure as well, where there would be a complaint. I also want to know, we'll talk about this on SF 120. We have another aspect here, which is the restoration of the rights to hold office. And I'm very sensitive in terms of cross-checking that and making sure that there is eligibility on that. The nightmare, right, would be someone who thought they were eligible, attested they were eligible, was not eligible, and we found out either post-certification in the middle of the election period. And that, I would say, is one where we're particularly at risk, and we're trying to, we have a few potential solutions on that as we implement SF 120. Certainly, that is passed, and we're implementing that. So there's a little bit in our updates as well, and that'll be another question we're grappling with at the time of certification for nomination for holding office. Thank you.
Senator Landon.
Mr. Chairman, thank you. Mr. Rubino, thank you for your cautions. I really appreciate this discussion because I think it's an important one. I guess my question is, does the legislature have any purview at all to consider what that residency is? I know it's in the Constitution. Is there any flexibility at all? Or do we have the ability to define what we consider to be 1 year? I guess I don't have the Constitution in front of me. I can't remember if that's specific to 1 year prior to the general election, or if it just says you have to live here for 1 year. If that's the case, don't we have the consideration in front of us that we can define what that residency requirement is?
Mr. Urbino?
Thank you, Mr. Chairman. I don't have the Constitution in front of me either. If somebody has the provision, they can read that and then.
Got it.
Senator Case?
It says no person shall be a senator who has not attained the age of 25 years or a representative who has not attained the age of 21 years, who is not a citizen of the United States and of this state, and who has not for at least 12 months preceding his election resided within the county or district in which he is elected. And so, it comes down, you're not elected in the primary. You just win a primary. You're nominated. You're elected in the general election.
So, Mr. Chairman, just to come back at my colleague from the Senate just a little bit. So when you reference an election, does the election begin at the filing?
When
And
you
you're
get
interpreting
elected,
it, I'm assuming you're interpreting, it is the November 6th date. It is the election day.
no, it's, the language says preceding his election, the act of being elected. That only happens one time. That only happens at the general. Doesn't happen in a primary. You're not elected to this office except for. I don't think we have wiggle room on this one. I think we just go for it.
Okay, Mr. Chairman, I'll stand down.
Bingo.
Thank you, Mr. Secretary, Mr. Urbino. Any additional public comment?
Thank you, Mr. Chairman. Gigi Lehman from Commerce County again. So I've been thinking in my head as a tech person as to, where do you follow the dots to figure for residency that we currently have in place? And the only thing that comes to my mind is motor vehicle and when you register a vehicle. That shows where your residence is, or at least where you get your mail, because there's people who do PO boxes. But those were things that come to my mind to verify. Again, if you have your voter ID, that helps with that piece a little bit too. And maybe on voter ID, you actually ask for a physical address. Don't know. I'm not one of those people that do a PO box. I know some people do that. I have a physical address. So with that said, just thought I'd throw that out there because those are the pieces that in government we have that actually ask you for your birth certificate in order to get a driver's license, that motor vehicle. To prove it, people are going to obviously, when they want to get their tags renewed on their vehicles, they're going to have that go where they're going to get, could be a PO box again, but nonetheless, those are the things that are coming to my mind. But again, if they do a PO box, that becomes opening another can of worms of how you're going to verify that. If you look at utilities, it's a concern to me because there's people that own multiple properties and they have multiple utilities at multiple places. And I think we had an issue over there in Laramie County with regards to somebody having exactly that, a couple of residencies. That was the state legislator. So those are things for food for thought as to what you need to be looking at that you can have, or you check some balances that show your birth certificate that yes, you're a US citizen, and then what you do, where you get your stuff. Just thought.
All right, thank you, Ms. Lehman. Any additional public comment? Nope, I will close public comment.
Move the bill.
Moved by Senator Case and seconded by Representative Chadwick. Any amendments to this bill? Senator Scott?
Mr. Chairman, on and against the bill.
Okay.
Mr. Chairman, I'm persuaded by this conversation that the constitutional provision is going to govern and we can't change it. And the existing law is consistent with the Constitution. This proposed thing is consistent with the Constitution. It's supposed to add a little clarity, but I would suggest to you the discussion in this committee indicates that it's going to cause more confusion than clarity. And frankly, we're looking at a 20-day budget session with time constraints. I don't think we're gaining enough I think this has potential for wasting quite a bit of time in the session is unnecessary. So I would urge us to vote no.
Gotta fill my 20 days with something to do. Senator Barlow.
Thank you, Mr. Chairman. So I will differ from my good colleague, Senator Scott, in that I think this is actually the clarity that I think folks do seek, in that it has been, I think, pointed out in the testimony that a previous Secretary of State and our current Secretary of State has not had this question come before him in his tenure, has had to make that determination of when that 12 months, what the starting point is, where you work back from. Is it the time you take your oath of office or your first day of office? Is it the certification of the state canvassing board? Is that the official, or is it the general election? And I think from a candidate perspective and from the voter perspective, it is the date of the general election. And so I think this actually adds a simple clarity to something that we don't have to interpret it anymore. And I think it is consistent with what the constitutional language, the plain reading was says. Thank you, Mr. Chairman. So I'll be in supportive of it.
What?
Okay. The roll call vote.
Mr. Chairman, roll call for 24 LSO 0094 version 3 candidates for state legislature residency requirement. Senator Barlow. Senator Boner. Senator Landon. Senator Scott. Representative Chadwick. Representative Harrelson. Representative Harshman. Representative Knapp. Representative Newsom. Representative Ottman. Representative Wiley. Representative Yin. Co-chairman Case. Co-chairman Olson.
Aye. Yep. What was the vote on that?
11-3.
11-3. Do pass. All right. That's a Senate bill, I think.
Come back at 2.
We'll come back at 2 o'clock.